The motions in that petition will be read by my learned brother, by my extreme right.
This is an election petition by the two petitioners against the first, second, and third respondents. The first petitioner, Abubakar Atiku, was a candidate at the presidential election held in Nigeria on the 25th day of February 2023. He was sponsored by the second petitioner, People's Democratic Party. The first respondent, INEC, was established as one of the executive bodies created in Section 135 of the Constitution of the Federal Republic of Nigeria, 1999, with power to, among others, organize, undertake, and supervise all elections to the offices of the President and Vice President and others. On Saturday, the 25th of February 2023, the first respondent conducted election into the office of the President and the Vice President of the Federal Republic of Nigeria and the National Assembly simultaneously. The petitioners and the second, third respondents, along with 16 others, participated in the election. At the conclusion of the election, the first respondent declared the results, by which it is indicated as follows. We show the result for out of the two contestants here we are concerned with. The APC of Tinubu Bola Ahmed and Tinubu Bola Ahmed scored were declared to have polled 8,794,726 votes, and Atiku and the PDP 6,984,520 votes. Petitioners were aggrieved by the outcome of the election, so they filed jointly this petition to challenge this election. The grounds of the petition were four, and these were stated as follows. One, that the election of second respondent is invalid by reason of non-compliance with the provisions of the Electoral Act 2022. The election of the second respondent is invalid by reason of corrupt practices. The second respondent was not duly elected by a majority of lawful votes. The second respondent was at the time of the election not qualified to contest the election. The petitioners are seeking the following release, that it may be determined that second respondent was not duly elected by the majority of lawful votes cast in the election, and therefore the declaration and return of the second respondent as the winner of the presidential election of the 25th of February 2023 is unlawful, wrongful, unconstitutional, undue, null and void, and of no effect whatsoever. B, that it may be determined that the return of second respondent by the first respondent was wrongful, unlawful, undue, null and void, having not satisfied the requirements of the Electoral Act and the Constitution of the Federal Republic of Nigeria, which mandatorily requires the second respondent to score not less than 1/4 or 25% of the lawful votes cast at the election in each of at least 2/3 of the states in the Federation, and they put the "and" in capital letters, and the Federal Capital Territory, Abuja. C, that it may be determined that the second respondent was at the time of the election not qualified to contest the said election. D, that it may be determined that the first petitioner having scored the majority of lawful votes cast at the presidential election of Saturday, 25th February, be returned as the winner of the said election and be sworn in as duly elected President of the Federal Republic of Nigeria. In the alternative, another directing the first respondent to conduct a second election runoff, in brackets, between the first petitioner and second respondent. In the further alternative, that the election to the office of the President of Nigeria held on 25th February be nullified and a fresh election, rerun, be ordered. G, any such further others as the Honorable Court may deem fit to make in the interest of justice. Upon being served the petition, the respondents joined issues with it by filing the respective replies, incorporating preliminary objections and made other applications. Some of the applications filed by the parties were heard and rulings delivered at the pre-hearing stage, while some were heard and rulings on them reserved till the time of the judgment of the court. We now proceed to consider them. 7 applications were filed and argued by the respondents during the pre-hearing session of this petition. 2 each of the said applications were filed by the first and second respondents, while 3 were filed by second respondent. First respondents' 2 applications were filed on the 19th of April this year and the 9th of May. The first of his 2 applications, dated and filed on the 19th, which also largely reflect the position of second respondent in his first two applications and third respondent in his first application. First respondent sought an order striking out paragraphs 92. We gave the paragraphs of the petition on the grounds of their vagueness. Several paragraphs which you get there as you get your the judgment, for being generic, imprecise, and lacking in specificity to elicit a reply from it. B, an order striking out paragraphs 129 and 138 of the petition for failure to join necessary parties. Among other grounds, the two necessary parties are Yaya Bello and one Adevo, the chairman of a local government in Kogi State. 3, another striking out the ground of the petition that second respondent did not score majority of lawful votes as contained in paragraph 16C of the petition for incompetence and lacking in specificity and materials in the pleading for a sustenance. Consequent upon 1 to 3 above, another striking out paragraphs A and B and D are sought in paragraph 130 of 150 of the petition, another striking out the ground of the petition that the election is invalid by reason of non-compliance. Consequent upon 5 above, another striking out the ground of the petition alleging that the election of the second respondent is invalid by reason of corrupt practices as contained in paragraph 16B of the petition for lacking specificity and material facts in the pleading for a sustenance. 7, another striking out the ground of the petition that the second respondent was at the time of the petition not qualified to contest the election as contained in paragraph 16A of the petition for lacking specificity. 8, another striking out the ground of the petition that the second respondent was at the time of the election not qualified to contest the election. 9, consequent upon 1 to 8 above, another striking out and dismissing the petition for being incompetent. Frivolous, vexatious, abusive. In the alternative to the above, another striking out paragraphs, prayers A, B, C, and D of the petition are sought in paragraph 150 for being incongruous, contradictory, and self-defeatist. The grounds of the petition were stated there, and we set them out, which you get. Second respondent also filed a similar preliminary objection, application for preliminary objection, seeking striking out of the petition or portions of it. A single prayer on the application is an order of the court striking out jointly and or severally paragraphs 14 and 15, 19 to 81, 87 to 104, 108 to 128, and 133 to 150 of the petition for being fundamentally defective. The third respondent on this part in his first application on the same issue filed, we gave the date, sought similar prayers like first and second respondents. All 3 respondents also had issues with the replies petitioners served on them in response to their own replies. Their main complaint this time is that the said replies went beyond the ambit of replies and raised new issues and facts like particulars of the non-qualification of second respondent for the election and his dual citizenship of Republic of Guinea, all of which, according to the reply of the petitioners, impacts on his qualification as a candidate for the election. Those new facts, the complaint tended to amend or reconstruct the petition and so overreach them, even as they do not have any further opportunity to join issues petitioners on them. Other paragraphs of the replies, they said, did not raise new issues, but merely repeated averments already contained in the petition, and so have no place in the reply. For these same reasons, they sought striking out with additional statements, witness statements on oath, and list of documents that accompany the said replies. Besides the above, second respondent had a third application that was peculiar to it. In the said application, which was also filed on the 13th of May 2023, second respondent again sought the striking out of the entire petition, this time on the following 4 grounds: that the entire petition constitutes a gross abuse of the process of court by reason of an originating summons in suit number SCCV 354-2023, filed by the Attorneys General of Adamawa, Akwa Ibom, Delta, Edo, and Sokoto states. All of them controlled by the second respondent, as he put them, as he called them, as second respondent put it, at the Supreme Court of Nigeria against the Attorney General of the Federation, where the said plaintiffs raised against the Attorney General of the Federation the same issue here of first respondent's failure to transfer or transmit poll unit results from his BVAS to his result viewing portal IREV in the 25th February 2023 general elections. The plaintiffs wherein first respondent mentioned sought in their suit declarations that the 2023 elections were fundamentally flawed and so invalid, null and of no effect, which is what petitioners also seek here. So this petition constitutes gross abuse of process. There were other grounds for that application, as I shall show later when considering it. All 7 applications were supported with affidavits and written submissions of applicants, which were in turn countered by the petitioners with counter affidavits and written submissions of their own. I shall now proceed to consider the merits of the applications. For ease of reference, I shall group the three sets of applications into groups A, B, and C. I start with the first three applications of respondents that attacked the validity of the petition, and all its paragraph reliefs claimed and grounds on which it was sought. First respondent's first application, that is the one filed on 9th of April. I start with that one. First respondent set out the following issues for determination in his 9th April 2023 application. We set them out. It argues its issues 1 and 3, you get it, so there's no point arguing it, time is going. It argues its issues 1 and 2 above separately and took issues 3 and 4 together. In seeking the striking out of paragraphs 9, 2, 3, 93, all set out there, of the petition on grounds of their vagueness, imprecision, and lack of specificity to elicit a reply from it, first respondent, that is INEC, relied principally on paragraph 4.1, sub 1 of the first schedule to the Electoral Act, which states as follows. It says, an election petition under the Act shall state clearly the facts of the election petition and the grounds on which the petition is based, and the relief sought by the petitioners. Relying on Ugu and Ararume and a number of cases all set out there, Council on First Respondents have argued that paragraph 4.1, the said paragraph 4.1 of the first schedule of the Electoral Act implies compulsion and makes it mandatory for petitioners to plead the facts of their petition. They submitted that an election petition that is vague, imprecise, omnibus, nebulous, or generic is contrary to the provisions of paragraph 4.1d of the Electoral Act and so liable to be struck out. The Senate Council then carefully took on each of the said paragraphs and advanced reasons why they are vague, generic as a complaint. Council also argued that the petitioners in paragraphs 129 and 130 of their petition made allegations of unlawful acts allegedly carried out by one Honorable Friday Adejo, Governor Yaya Bello of Kogi State, and some unnamed persons in the course of the presidential election. Yet those persons were not joined to the petition, so those two paragraphs are also liable to be struck out. Council cited Bambe and Adetunji, Olori Ode vs. Oyebi, and Babatola and Alade Jono to say the court lacked jurisdiction to enter judgment or make orders against persons that are not before it. Responding to the first limb of first respondent's contention that the said paragraphs of the petition are vague and imprecise, the senior counsel to the petitioners argued that the said paragraphs were pleaded in support of the second ground of the petition, alleging that the presidential election was bedeviled by corrupt practices. Prime among those practices, they said, are suppression of votes, manipulation of beavers' machines, and destruction of electoral materials and ballot boxes. Specific instances of these corrupt practices that took place in various states and local governments, they argued, were laid bare in the petition with particulars of the allegation. They argued that first respondent, instead of considering the paragraphs of the petition holistically, seems to have considered them in isolation and haphazardly, hence its wrong conclusion that the petition was vague, imprecise, and without necessary further particulars. While admitting that the names of polling units were not specifically stated in the petition, Petitioners' Counsel submitted that petitioners stated in different paragraphs of the petition that the polling units affected were to be contained in the statistician's report to be relied upon at the hearing of the petition. They cited the cases of Oluwedun vs. Ajayi, Awolaja and others, versus Citrate, and East Horizon Gas Limited versus Afiok and others, to submit that petitioners have by that pleading incorporated by reference the said statistician's report. On the argument of the first respondent that the petition did not disclose any reasonable cause of action and so constituted abuse of process, Petitioners' Counsel argued that first respondent was by that argument trivializing matters of high constitutional importance raised by petitioners in the petition. They submitted that a petition that touches on correct interpretation of Section 133(2)(b) of the Constitution of this country, vis-a-vis the return of second respondent and the qualification or disqualification of second respondent, regulated solely by Sections 131 and 137 of the Constitution, cannot by any means be said to disclose no reasonable cause of action. On first respondent's contention that petitioners' failure to join Honorable Adejo and Governor Yaya Bello and unnamed thugs against whom they made allegations of criminal misconduct in paragraphs 129 and 133 of their petition made those paragraphs of the petition incompetent and liable to be struck out, Counsel to the petitioner submitted that Section 132 of the Electoral Act has specified the persons who may be joined as petitioners or respondents in an election petition. That Honorable Friday Adejo and Governor Yaya Bello, having not participated in the election or returned, petitioners are not in violation of the Electoral Act or any rule of law in not joining them. Besides, they also argued, no relief was claimed against the said two men, so they cannot be said to be affected in any way by the eventual outcome of the petition. Now, this is the way we resolve this. My Lord, resolved it. Now, paragraph 4.1 of the first schedule of the Electoral Act, as amended, states thus: 2020 states thus: an election petition under this act shall D. State clearly the facts of the petition, and the ground or grounds on which the petition is based and relief sought by the petitions. This provision is so clear and direct that it does not require any aid in its interpretation. It simply restates in mandatory terms the first rule of pleading that claimants, in this case a petitioner, shall state clearly, quote and unquote, the facts of the election petition, end quote again, and the ground or grounds on which the petition or claim is brought. This requirement / duty to plead one's complaints and facts clearly in the statement of claim / petition, not reply, is a basic rule of pleading even in ordinary civil proceedings. Emeka Agu in JSC, Natonda versus Ajani, put that point across most forcefully when he said that, and I quote, he said, "It appears to me that the rule which required every fact, upon which a party intends to rely at the hearing of the goes to the fundamentals of justice. For no one can defend the unknown. If one has to defend or counter a fact made by his adversary, the one must have due notice of that fact to enable him prepare for his defense. That is the very essence of pleading. As it goes to the very root of the rule of audio alteram partem, one of the twin pillars of justice, it would be misconception to describe it as mere technicality or regularity. It's a matter which cannot be waived. Indeed, by a long line of decided cases, it has been long settled that any evidence on the fact that ought to have been pleaded but is not, goes to no issue at all at the trial and ought to be disregarded," end quote. Now, the complaint of first respondent is that the petitioners in their petition did not state their case as clearly as required by Section 41D of the Electoral Act, 2002. It complains that petitioners' complaints were vague, imprecise, and lacking in particulars. It does not appear to me that this complaint can by any means be waved away as idle. If anything, even the petitioners seem to have admitted that they did not plead those necessary facts. For their response to that contention, as shown earlier, is that they pleaded a statistician's report, which contains the required details of the polling units where the corrupt practices they alleged took place. Incidentally, the said report, a very voluminous four-part document, the later tendered through its maker, Mr. Samuel Oduton, PW1, during the trial, shows on its face that it did not even exist at the time they filed their petition, and so was not served on respondents along with the petition to enable them exercise their constitutionally guaranteed right of responding fairly to the corrupt practices, quote and unquote, alleged particularized in it, and if necessary, also engage their own expert to reply to it. Engage their own expert to reply to it. Yes, the principle of incorporation, by reference relied on by them, that is petitioners, is part of our adjectival law and is supported by a fairly long line of cases, including MMA versus NMA, Ekpemupolo versus Edremoda and others, JFS Investment versus Brawalai Limited, Elo versus Idaosa, Abode Brothers Limited versus Niger Construction Company Limited, and another. But that principle cannot by any means override the fair hearing trial provisions of Section 36 of the 1999 Constitution of this country, which also underpins the rationale for exchange of pleadings by parties. See once again the dictum of Emeka Agu and Atonda and Ajani already quoted. A statistician's report that is supposed to contain missing particulars in a petition, but which was only filed in the middle of hearing of the same petition, long after the time for exchange of pleadings had closed and even after petitioners had called as many as 16 witnesses in proof of their case, as happened in this case, cannot serve that purpose of audi alteram partem, let the other party also be heard too. In short, the tactics employed by the petitioners in this case as regards their pleadings, and the petitioners and the statistician's report referred in it, is to say the least most unfair and definitely negates the current practice regime that emphasizes front-loading of processes. Such dishonorable practice can only be likened to the unlawful boxing tactic of hitting one's opponent below the belt or from behind, which in the sport of boxing is penalized promptly with deduction of points. It cannot be different here. The said statistician's report, which is exhibits PAH1, PAH2, PAH3, and PAH4 in this proceeding must be and is hereby discountenanced. That conclusion should make the resolution of this issue of imprecision of the petition fairly easy. I shall nevertheless want to exercise caution and still consider the paragraphs of the petition attacked by first respondent, but it shall only be as they stand in the petition. In that regard, I am satisfied that paragraph 92 of the petition, where the petitioners allege wrongful calculation of polling unit results in various local governments of Sokoto State is lacking in particulars of the particular polling units affected and so liable to be struck out. Paragraphs 93 and 94 of the petition, where petitioners allege that first respondent officials failed to properly fill election forms in Kano State, I think sufficiently meets the requirements of paragraph 41D of the first schedule to the Electoral Act 2022. Paragraph 95 of the petition, where the petitioners allege that results in unspecified polling units in some local government areas of Kogi State were, quote, manipulated through and by the inflation of the second respondent's votes and depletion of the petitioner's votes, end quote, is, in my opinion, bad for vagueness, not only as to the polling units where the alleged manipulation occurred, but also as to the actual lawful votes of petitioners and second respondents allegedly depleted and inflated, respectively. The need to plead the exact figures of votes affected by the alleged manipulation becomes even more crucial, in my opinion, when account is taken of paragraph 15 of the first schedule of the Electoral Act, stating that, and I quote, this is what that paragraph 15 says, when a petitioner claims the seat alleging that he had the highest number of valid votes cast at the election, which is what the petitioners are doing here, the party defending the election or return shall set out clearly in his reply particulars of the votes, if any, which he objects to, and the reasons for his objection against such votes, showing how he intends to prove at the hearing that the petitioner is not entitled to succeed. Second and third respondents can only properly exercise their right under this provision, requiring them to, quote, give particulars of the votes claimed by the petitioners that they object to and the reasons for the objection against such votes, after petitioners have themselves set out clearly the lawful votes depleted by the manipulation alleged by them. Paragraph 97 of the petition, in my opinion, are matters of proof at the hearing, even more so as the petitioners have stated in those two paragraphs that the disruption of elections in Adavi and Okei local government areas of Kogi State by agents of second and third respondents alleged hearing was captured in video recording, which they petitioners would lead evidence in proof. Paragraph 98 of the petition, where petitioners allege that elections in 10 polling units were disrupted and there were no results from the said polling units, end quote, is bad for vagueness and specificity, insofar as it does not specify the affected 10 polling units. Is therefore also liable to be struck out. I am also of the opinion that paragraphs 99 and 100 of the petition, also attacked by first respondent, has to do more with proof, which is a matter for the substantive hearing, especially as infractions complained of in them were again, according to petitioners, captured in a video recording which they promised to rely at the trial. Paragraph 101 of the petition, where the petitioner simply complained of failure of first respondents officials to properly fill election material, seems to me sufficient pleading. Paragraph 102 of the petition, where the petitioner simply alleged that infractions occurred in polling units unidentified in various local government areas of Kogi State, and, quote, these failures enabled the results of the polling units in the said LGAs to be manipulated through and by the inflation of second respondents' votes, and the depletion of petitioners' votes is bad and vague as to the particulars of the specific polling units and votes of petitioners and respondents affected by the said manipulation of inflation and deflation. It fails to meet both the requirements of clear pleading of facts of the petition and paragraph 15 of the first schedule of the Electoral Act aforesaid. In fact, the following dictum of the lead judgment of Tabai GSC in Belgora and Ahmed clearly says so, my lord. We have already reproduced all these things in, CA03, and we don't intend to read. In any case, you get it and you see it. See also PDP versus INEC. For the same reasons, I am also of the opinion that paragraph 103 of the petition, where the petitioner simply averred generally that, quote, first respondent wrongly entered incorrect results for the petitioners in Borno State, is bad insofar as the polling units in Borno State affected by the incorrect results are not stated. I am, however, of the view that paragraphs 104, 105, and 106 of the petition sufficiently plead necessary for us to elicit appropriate response from respondents, even more so as paragraphs 104 merely alleged bypass by first respondent of the use of beavers machines in the presidential election in Benue State, while paragraphs 105 and 106 simply stated the petitioner's ground that second respondent was not elected by majority of lawful votes. In respect of paragraph 104 of the petition, first respondent complains that the petitioners there contended that the entire results of the presidential election were wrong, yet they did not plead the results they perceived to be correct, so it is also vague pleading. I am of the view that that complaint is better considered while considering the merits of the petition. That is even more so as it appears to us that paragraph 104 seems averred to by petitioners to meet the provisions of paragraph 4 sub 1, C of the first schedule of the Electoral Act that requires them to state in their petition, among other, the scores of the candidates in the election. To that extent, paragraph 104 cannot be faulted by application at this stage, let alone sought to be struck out in limine. Paragraph 105, 109, 110, 11, 12, and 113 of the petition merely pleaded facts as to whether second respondent, who by first respondent's own showing did not poll up to 25 of the total votes of the Federal Capital Territory, was properly returned by first respondent having regards to the provisions of Section 134B of the 1999 Constitution of the Federal Republic of Nigeria and other relevant statutes. It is therefore in order. I am afraid paragraph 114 of the petition 115 and 116, and paragraph 4, where they said purported results from 6,418 polling units have and indicate zero accreditation, and paragraph 118, where they have that critically, paragraph 118 and 119 are all bad for lack of particulars of necessary facts. As for the statistician's report, again referenced by them for the said particulars, I hereby reconfirm my earlier finding and conclusion on it. Paragraph 120 of the petition is not challenged by first respondent, so I shall overlook it, at least for now. The petitioners in paragraph 121 of the petition allege that first respondents, presiding officers of polling units, failed to properly fill and countersign alterations in election forms, including forms E, C, 8B, and blah, 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 but they did not mention the polling units, what local government and state said infractions took place. They simply reference the same statistician's report. This paragraph is bad for imprecision and so also liable to be struck out. Paragraph 122 to 125 of the petition are not challenged by respondents, so I shall skip them. In paragraph 126 of the petition, the petitioners complained that all over Nigeria, there were manifest cases of overvoting. The total of the affected polling units in the various states are set out in the statistician's report, pleaded and relied upon by the petitioners. This pleading is also, end quote, sorry. This pleading is also bad for vagueness. My earlier position on the statistician's report referenced by the petitioners is also reaffirmed. Paragraph 127 and 128 of the petition are not challenged by first respondents, so they are also skipped. I do not share the view of first respondent that paragraphs 129, 130, that's INEC, that paragraphs 129, 130, 131, and 132 of the petition are bad for lack of imprecision. Petitioners in those paragraphs carefully pleaded the specific polling units and numbers of votes therein that they claim were affected by the cancellation of elections complained by them. I am, however, of the opinion that the second complaint of first respondent against paragraph 129 of the petition, that is also deserves to be struck out for petitioner's failure to join Honorable Adejo, chairman of Oloma Boro local government of Kogi State, accused by them of having led thugs at gunpoint to force electoral officers in named polling units in Oloma Boro local government to declare concluded elections in the said units cancelled, is well made. The petitioner's response that not only was no relief claimed by them against Honorable Adejo, he did not even participate, quote unquote, in the election, neither was he returned, so it's not a petition contemplated by Section 132 of the Electoral Act to be joined to an election petition. It's not a valid response. Section 133 of the Electoral Act only deals with the issue of which contestant of an election ought to be joined in an election petition by a co-contestant. It has nothing to do with the issue of joining of third parties against whom allegations of electoral infraction are made by practitioners, as in this case. Such petitions must be joined to the petition if the court is not to be exposed to the risk of infringing their fundamental right to fair hearing guaranteed by the Constitution. It is also of no moment that no relief was claimed against such persons in the petition. What is important is that allegations of electoral malpractice, which will require the court to make findings, including condemnation of the alleged conduct, where necessary, are made in the petition. Support for that position can be found in Wankwo and Yaradua, where Muntaka Kumasi JSC, after reproducing the provisions of the then newly enacted Section 1441, Sub 2 of the Electoral Act, which is now Section 1332 of the Electoral Act 2022, and confirming that that provision had done away with the old regime of the Electoral Act that required petitioners to join all relevant electoral officers of INEC that conducted an impugned election. In addition to INEC, said, this is what his lordship said, he said, unless the conduct of a petitioner who is not an agent, or the conduct of a party who is not an agent of the commission is in issue, it will then be necessary to join such party as a necessary party to the petition in order to afford such party a fair hearing, end quote. As regards the consequence of failure to join such necessary parties on the petition itself, his lordship Kumasi again said as follows. However, where such a party is not made a party, it will not result into the whole petition being struck out. But the particular allegation against such party is liable to be struck out, end quote. That is the fate of paragraph 129 of the petition, where allegations of electoral malpractice were made by the petitioners against Honorable Adejo, yet he was not cited in the petition. Incidentally, this is also one of the main reasons the Supreme Court gave in dismissing the appeal of the petitioners in the Odo State governorship case of Eita Yojegede and another versus INEC, where allegations were made by the petitioners in that case against the then National Caretaker Committee chairman of the present head respondent APC, Governor Mai Malabuni of Yobe State, yet he was not joined to the petition by the petitioners. Paragraph 129 of the petition must therefore suffer striking out. For the same reason, paragraph 133 of the petition, where similar allegations of an alleged gun-toting Governor Yahaya Bello of Kogi State, leading talks to compel cancellation of concluded elections in polling stations were made, yet he was not joined to the petition, must also be struck out. Paragraph 135 and 136 of the petition were not challenged by first respondents, so they are hereby skipped. I consider this a convenient point to consider paragraphs 137 and 142 of the petition, which learned senior counsel to INEC further complained was also barred for non-joinder. Counsel's argument this time was that the petitioners were also seeking in those two paragraphs to avoid the entire results of the presidential election in Lagos and Kano states, as declared by INEC, where Mr. Peter Obi of the Labour Party and Rabiu Musa Kwankwaso of the New Nigeria People's Party scored the majority of the lawful votes. Yet Peter Obi of the Labour Party and Rabiu Musa Kwankwaso were not joined to the petition, so those paragraphs were also barred and liable to be struck out. I consider this argument misconceived. In fact, it seems to overlook Section 134, sub 4 of the 1999 Constitution, stating expressly that, and I quote, "For the purposes of an election to the office of President, the whole of the Federation shall be regarded as one constituency," end quote. That is the position as it relates to a presidential election. Percentages of votes polled by presidential candidates in any of the 36 states of the Federation or even the Federal Capital Territory only become of consequence when the issue verges on whether the candidate returned also satisfy the provisions of Section 131B and 2 of the 1999 Constitution, as amended, requiring him to poll 25% of votes cast in at least two-thirds of the 36 states and the Federal Capital Territory. Outside of that, how many votes a presidential candidate polled in any of the states of the country is of little significance in an election petition challenging return in a multi-party presidential election. It certainly has no bearing on the question of who an aggrieved party challenging a presidential election return should join to his petition among the candidates that contested the election with him. By Section 133 of the Electoral Act, the only other candidate in the election the petitioner can properly join to his petition is the person returned as the winner of the election. See further on this the cases of Buhari and another versus Yusuf versus Obasanjo and 50 others, Obasanjo and Yusuf versus others. See particularly Buhari and another versus Yusuf, where it was said by, and I quote, by the Supreme Court, where it was said that, and I quote, "An unsuccessful candidate in an election cannot be made a party to an election petition against his will," end quote. We also do not agree with first respondent that paragraphs 141, 41, and 142 of the petition were vague or imprecise. But I do not, sorry. I am rather of the view that facts necessary to elicit an appropriate response from the respondents of the electoral infractions complained of by the petitioners have been pleaded in those paragraphs. I, however, agree with first respondent that paragraph 142 of the petition, where the petitioner simply complained that first respondent deliberately entered wrong results for 22 name states herein, paragraph 44, where they averred that there were discrepancies on very large scale at the various local governments, various levels of recording and collation of results, particularly between the polling units and the ward polling centers, without specifying the said polling units and ward collation centers, where this said, quote and unquote, large-scale discrepancies took place, and paragraph 144, where petitioners gave notice that they would rely on their same flawed statisticians' report, among other documents they did not front-load, are bad and liable to be struck out for vagueness. Paragraph 142 of the petition, where petitioners simply stated as ground 4 of their petition that the petitioners aver that second respondent was at the time of the election not qualified to contest the election, not having the constitutional threshold, quote and unquote, that is all they said, is also imprecise and vague as it gives no particulars of any of the several qualifying and disqualifying factors set out in sections 131 and 137 of the Constitution. The main purpose of pleadings, as further fortified by paragraph 4 sub 1b of the first schedule of the Electoral Act, we repeat, is to properly and clearly inform the adverse party of the case is coming to meet, so that he can respond appropriately to it. That is fair hearing. That requirement of the law does not permit parties to keep their cards face down, as petitioners did in paragraph 146 of their petition, when they simply aver generally that second respondent was not qualified to contest the 25th February presidential election, without revealing in what form he was not qualified or disqualified for the election. that paragraph of the petition falls far short of the requirements of paragraph 4(1)(b) of the first schedule of the Electoral Act, and so liable to be and must be struck out. Conclusion on issue 1 of first respondent, the sum total of all the foregoing is that while paragraphs 129 and 133 of the petition are liable to be struck out for non-joinder, to which Mrs. Adejo and Governor Yahaya Bello of Kogi State accused the petition of committing electoral malpractices, paragraphs 92, 95, 98, 11, 121, 126, 129, 133, 143, 144, and 146 are vague, imprecise, and lack particulars, and so fall short of the requirements of paragraph 4(1)(b). They are all therefore ordered struck out. Paragraphs 93, 94, 96, 97, 99, 100, 101, 102, 104, 105, 108, 109, 100, 111, 112, 113, 114, 115, 16, 118, 19, 120, 122, 125, 130, 134, 138, 139, 140, on the other hand, are in order and properly pleaded. Now, issue 2 of first respondent in this same application reads whether, having regard to the mandatory provisions of paragraph 4(1)(b) of the first schedule of the Electoral Act, a reasonable course of action has been disclosed in respect of grounds of the petition contained in paragraph 16(a), (b), C, and D of the petition to warrant further or any adjudication on same. Counsel, on behalf of first respondent, this time anchored the arguments principally on the grounds on which the petitioners founded their petition. Counsel reproduced paragraph 16(a), (b), and C of the petition where the petitioners alleged, we set them out. The next reference, section 134 of the Electoral Act, stating that an election may be questioned on, among others, that the election was invalid by reason of corrupt practices, and argue that this provision, that is section 134, has a proviso in section 135(1) to the fact that an election shall not be liable to be invalidated by reason of non-compliance with the provisions of the Act if it appears to the election tribunal or court that the election was conducted substantially in compliance with the principles of the Act and in non-compliance with substantially affect the result of the election. Relying on the cases of Ojukwu and Yaradua and Yusuf as a judge, learned counsel submitted that for petitioners to sustain their ground of corrupt practice and non-compliance of the election with the provisions of the Act, they are required to not only plead the fact of non-compliance, but further assert positively in the petition and prove that the non-compliance and corrupt practice complained of substantially affected the result of the election. To properly do that, they argued petitioners must plead and show how many votes were affected by the irregularities and that the deduction of such votes would void the return of second respondent as the winner of the election. They said not only did the petitioners not assert in their petition that the non-compliance complained of substantially affected the election, they did not also plead the votes or polling units affected by non-compliance to enable this court form an opinion on that non-compliance and corrupt practices complained of substantially affected the result, or that second respondent polled majority of lawful votes in the election and so ought to be returned. Without those facts in the petition, the petitioner's counsel submitted have simply blown quote-unquote muted trumpets and their petition lifeless and failed to disclose a substantial cause of action, so it is liable to be dismissed. Resolution of issue 2. This issue does not, in my view, deserve any serious consideration. The reason being that petitioners expressly stated in paragraph 17 of their petition that, quote, the petitioners have vowed that the election was not conducted in accordance with the provisions of the Electoral Act and other relevant laws, and that the non-compliance substantially affected the result of the election, in that the second respondent ought not to have been declared and returned as the winner of the election. That sufficiently answers the question of first respondent. Issues 2 and 3 and 4, the first respondent first application. The answer to first respondent, their issues 3 and 4, which they also argue together, basically relied on their contentions in issue 2 of the lifelessness of the petition to submit that the petition, as by reason of the alleged submission in the petition identified above, had become academic and constitute abuse of process of court, so this court is robbed of jurisdiction to entertain it. This combined issue is founded on issue 2, and since issue 2 has been determined against first respondent, issue 3 and 4 perish with it, and so are hereby resolved against first respondent. Now I come to second respondent similar application, seeking dismissal of paragraphs 14 and 15, 19 to 81. Huh? Okay. We didn't quite write it that way here. For this application, learned counsel second respondent simply said that the sole issue for determination, thus, which was that in view of the provision of paragraphs 14(1)(d) of the first schedule to the relevant Electoral Act and relevant judicial decisions, whether paragraphs 14 and 15, 19 to 81, 87 to 104, 527, and 108 of the petition are not liable to be struck out. We we set out the arguments, both of them. We said, in the course of determining first respondents' application on the same issue of vagueness and precision in the complaints, I dwelt extensively on the rationale for exchange of pleadings, generally and particularly in election particulars, as further set out by the lawmaker. I hereby adopt all those pronouncements. In the same exercise, I also considered and pronounced on the same complaints of vagueness, lack of particulars, generic and imprecision. Of the complaints of the petitions, paragraphs 92 to 146 of the petition, also made by the second respondent here, I there determined, we said what we listed, and we said, I abide by those findings. I shall therefore simply focus on paragraphs 14 to 19 and 147 to 150, and the few paragraphs between paragraphs 92 to 146 of the petition omitted by the first respondent in the application, determined the complaints of second respondent of whether petitioners' complaints in those paragraphs were vague, imprecise, and generic. I now start that exercise without prejudice to what I had said earlier, and which I hereby reconfirm on the invalidity of the statistician's report relied on by the petitioners for particulars of the averments in the petition. I am of the opinion that paragraphs 14 to 15 of the petition, where the petitioners specifically complained only about correctness of the contents of INEC forms, are so clear as to the issue raised and so not vague. Paragraph 16 of the petition are not attacked by first respondent and so are also skipped. We also do not find paragraph 20 to 20 of the petition where the vague. We do not also find paragraphs 20 to 20 of the petition where the petitioners complained that first respondent did not keep to his earlier promise of electronic transmission of election results to its IRF portal in real time when it returned this in vague. We, however, find vague, imprecise, and falling far short of the requirements. I, however, find vague, imprecise, and falling far short of the requirements of paragraphs 4, 1D, and 15 of the first schedule of Electoral Act 2022, the averments in paragraph 22 of the petition, where the petitioners complain that the result of the election as announced by INEC does not represent lawful votes, and that lawful votes cast for them were massively deducted from their scores. Those paragraphs ought to contain the lawful votes of the petitioners that were alleged, quote, massively deducted, as well as those alleged to have been allocated to second respondent by INEC. We find properly and sufficiently pleaded paragraphs 24 down to 72 of the petition. We, however, find vague, imprecise, and lacking particulars paragraphs 82 to 86 of the petition, where the complainants complain that permanent voters' cards collected in unit results where elections were collected or did not hold across the country is above 1,000, is above 1,810,206, which is the margin of lead between first petitioner and second respondent. Consequently, the turn of second respondent was hasty, premature, and wrongful. This pleading ought to contain the precise number of permanent voters' cards alleged collected in the polling units, which by petitioner's contention would have closed the margin of lead between first petitioner and second respondent to make the latter's return unlawful. Without that information, the complaint is difficult to understand and respond properly to, let alone resolve. Paragraphs 87 to 90, where the petitioners complain of corrupt practices in the conduct of the election, which practices they complained took the form, among others, of manipulation by second respondent through deliberate suppression and discounting of votes, is vague insofar as the polling units where the said corrupt practices took place are not stated. Paragraphs 92 to 97 of the petition, less paragraphs 135 and 36, also complained of by second respondent as vague, imprecise, and generic, have been dealt with by us while considering first respondent's petition on the same issue. We hereby adopt our findings in that application, resolving the complaints of second respondent in this application. As for paragraphs 135 and 136 of the petition, we have the view that paragraph 135, where petitioners complain of manipulation of election in Lagos State by first respondent, resulting in depletion of their votes and inflation of second respondent's votes, is vague in the absence of pleading of the number of votes so depleted and inflated. In respect of paragraph 136 of the petition, even the petitioners again complained, even the petitioners again complained that the votes returned by the first respondent for Obi Akpo and Port Harcourt local areas of Rivers State did not reflect the actual votes, did not express the actual votes scored in the said local government areas or even those updated to IRF by INEC and so liable to be voided. No correct quote-unquote figures of the actual votes cast as reflected in the IRF were pleaded. So it is also bad for vagueness and imprecision and therefore liable to be struck out. The sum total of the foregoing are complaints of vagueness, imprecision, and genericness of averments, all by second respondent against the petitioner, only made out as regards paragraphs 23, 82 to 86, 89 to 91, 92 to 95, 98, 121, 124, 126, 129, 133, 135, 136, 147, 144, and 146 of the petition. Accordingly, those paragraphs are hereby struck out, while the remaining paragraphs of the petition are deemed in order and pass the vagueness test of paragraph 4(1)(d) of the first schedule of the Electoral Act. In pronouncing the said paragraphs of the petition bad for vagueness and liable to be struck out, we are not unmindful of the argument of petitioners that second respondent's remedy lies in an application for further particulars and not striking out. We are, however, of the petition that application for particulars is only one of several options open to second respondent, who in any case is not under any obligation to help petitioners make out their case against him by asking for particulars of their generic and nebulous complaints. That is also the point that was made by Fabi EJS in PDP versus INEC, when his lordship said at page 524 that, and I quote, the application for another for further particulars or the like is merely a shield in the hand of a party who so desires, and not a sword to be used by a party whose pleading is grossly inadequate, insufficient, or devoid of necessary particulars. The decision in Olawekpo versus Saraki, cited by learned counsel on both sides, is in point. It is not the duty of a respondent to groom a petitioner on how to draft his petition, end quote. It is also quite revealing, if not even reassuring, we must say, that this argument of the petitioners of duty of second respondent to ask for further particulars, because that's their main argument, in their petition rather than asking for striking out the particulars, was also rejected by Muntaka GSC, while delivering lead judgment in PDP versus INEC in 2012. Even as the same argument had found favor with his lordship, that is Muntaka, 2 years earlier in his contribution in Nwankwo versus Yaradua. His lordship in the latter case of PDP versus INEC endorsed the stand of trial tribunal in that case that paragraph 12 sub 5 of the first schedule to the Electoral Act, same as paragraph 12(5) of this present Electoral Act, 2020, permitting respondents to apply to strike out a petition did not exist in the 2000 Electoral Act in force at the time Nwankwo and Yaradua was decided, and that made all the difference. Regarding the further argument of second respondent, petitioners complained that first respondent did not observe his own promises to transmit election results to IRF portal in real time, was caught and made comatose by Section 134 of the Electoral Act, stating Electoral Act. We think it is, I think it is neater and even safer to defy it to the main argument for determination on its merits, especially since that contention is also one of the main complaints of the petitioners in the petition itself. That is what case law decides. Advice is sorry. See again Nwankwo and Yaradua, citation given. Third respondent's application on the same issue of vagueness of paragraphs. It is our own application, that is the third respondent this time. It is own application of 8th May, third respondent, like the first and second respondents, also paid us to strike out all of paragraph 17 to 146 of the petition on the same grounds of vagueness, imprecision, blah, 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 and failure to join Mr. Adejo and Governor Yahaya Bello of Kogi State, against whom allegations of electoral infraction were made. Additionally, it's also complained that petitioners' averments in paragraphs 19, stated them, and 45 of the petition are all pre-election matters which occurred after the petition and outside the jurisdiction of this court, sitting as an election petition. Again, the petitioners argued in response that their complaints were properly pleaded in the petition, so not imprecise nor pre-election matters as alleged by third respondent. Resolution. Since the application of third respondents relates to the same paragraph of the petition objected to by first and third respondents, over which we have already made findings, we abide by and adopt those findings in determining the application of third respondent. We further hold that petitioners' averments in paragraphs 19, 20, 21, 35, 41, 42, and 45 of the petition are not pre-election matters. In fact, whereas the issues of the assurances given by INEC of real-time transmission of results to IRF raised by petitioners in paragraphs 19 and 20 of the petition, how the elections were generally funded by the federal government of Nigeria on account of those assurances as averred, and how first respondent transferred his in-house expert from one department to another before the election as alleged in paragraph 35 of the petition, cannot by any means give rise to a cause of action, let alone a reasonable cause of action. In petitioners, what is here? In petitioners, the averments in paragraph 42, 43, and 45 of the petition are simply notices by the petitioners to subpoena witnesses to testify about first respondents' omissions and commissions in the conduct of election, and so cannot by any means be described as causes of election, let alone pre-election matters for which they could have commenced action as alleged. In conclusion, the applications of first, second, and third respondents succeed only partly, and the following orders are made on them. Paragraphs 23, 82 to 89, 88 to 91, paragraph 95, 95, 98, 121, 124, 126, 129, 133, 135, 136, 143, 144, and 146 are hereby struck out as prayed. The remaining paragraphs of the petition attacked past the vagueness test and paragraph 4.1d of the first schedule of the Electoral Act 2022 and are hereby upheld. That leaves us with the standalone application of third respondent also filed on 8th of May 2023, as well as the 3 applications of third respondents, all objecting to petitioner's replies to their petition, to their reply, sorry. Second respondent, so we take that one. We try to produce the arguments there. We said, and then we went on to say that the thrust of the response of petitioner's counsel, that is 45543. The thrust of the petitioner's counsel is a suit number SCV 351 that was not filed by the petitioners. So this petition, sorry, okay, I'm still reading. It's 544. Said now it is settled position of law that once a court is satisfied that a proceeding before it amounts to abuse of process, it has the right and indeed duty to invoke its coercive powers to punish the party in abuse. Quite often that power is exercised by dismissal of the action that constitutes abuse of process. But multiplicity of actions, which is the complaint here, on the same subject matter and issue will only constitute abuse of judicial process if the parties in both actions are the same or previous to one another. See your CAF of Attorney General of Anambra State. It necessarily has to be so because except where a person is shown to be privy of another as recognized by law, no man can be punished for the actions or sins of another. That is the crux of the issue here. It is whether the petitioner, that's Atiku Abubakar, and his political party, the PDP, can be properly described as previous of the governments of Adamawa, Akwa Ibom, Bayelsa, Delta, Edo, and Sokoto states, who undisputedly instituted suit number SCCV against the Attorney General of the Federation before the Supreme Court of Nigeria. That question can only get a negative response for the government of a state, regardless of the political party platform on which its executive governor is or was elected, represents all shades of opinion in the state, including even those who may not belong to any political party at all. In fact, a state government is not even bound nor obliged to take instructions from the political party of the governor. Interestingly, our law reports are replete with cases where state governments elected on the same party platform with the federal government have repeatedly sued the federal government at the Supreme Court. A good example is this. Okay. A good example is recent new currency case. Which one is that? 581? Yeah? It's a new currency case that was instituted by the Attorneys General of Kogi, Kaduna, and Zamfara states against the federal government, even as both parties were APC governments. In that situation, one wonders where counsel would place this proposition of privity by affinity. There are other cases, we cited them, so we go on and on. Sorry. Now this thing now. In short, we reject this argument of second respondent of abuse of judicial process on account of litigation commenced by state governments against the Attorney General of the Federation. That is, as we also take note of the notice of discontinuance of case, the said suit number SCCV 354, 2023, filed by the plaintiff in that case since the 3rd of March 2023, which notice was tendered by the petitioners in this court as Exhibit PV in the course of the hearing of the main petition on the 6th of June 2023. This court is obligated by Section 1221M of the Evidence Act to take judicial notice of its proceedings. The other argument of note of second respondent in this application is the one of failure of petitioners to again join Friday Adejo and Yahya and its effect on the petition. We have already struck out the relevant paragraphs of the petition where allegations of malpractice were made against the two gentlemen. We abide by that decision. We shall simply add that we do not agree with second respondent's argument that the entire petition merits dismissal for non-joinder of those two men. The proper sanction in the circumstances of this case, as we have already pointed out, citing Nwankwo and Yaradua, is to strike out the paragraphs of the petition where those allegations were made. That order we also further add, and contrary to the argument of second respondent, will not affect the paragraphs where allegations were made against unnamed thugs. Unnamed persons cannot be joined to an election petition like it is sometimes done in trespass cases. See Obasanjo and Yusuf, where a similar argument was rejected out of hand by Kutigi and Pastor Chalon on JSC. Thus, it was said there that it said, quote, it is impossible to drag unknown touts, police, and hordes of others to court and join them. That would be bizarre, end quote. So, okay. So the next one, we now go to the challenges, the replies filed with the petitioners. All three respondents also challenge the validity of the replies and the accompanying witness statements on oath and list of documents petitioners served on them in response to their replies. Their common complaint in those petitions is that the said replies or paragraphs thereof offend paragraph 16 of the first schedule of the Electoral Act governing filing of replies by the petitioner, and so liable to be struck out. First respondent's objection was against the reply of first petitioner that was served on it. They are sought striking out of paragraphs 1.1, 21, 23, and 21 of the petitioner's reply, striking out the further witness statement on oath of DM, who later revealed himself in the production as Senator Dino Melaye, and PDPC, both deposed on 20th April, striking out the petitioner's list of additional documents dated the 20th day of April, which accompanied it. Sorry. The thrust of the argument, which is counsel founded principally, and we reproduced the arguments, and we reproduced the reply. To start with, I am not persuaded by the petitioner's argument that the new facts or issues raised by them in their impugned reply relate to non-qualification, which is one of the arguments, and not the conduct of the election by first respondent. So second respondent, who is supposed to be first respondent, that is INEC, who is supposed to be neutral in that matter, cannot be heard to be objecting to them. The issue raised by first respondent, that is INEC, actually relates to the competence of a major process before the court to which the reply filed by petitioners. It is an issue which counsel to first respondent as ministers in temple of justice, and even first respondent itself as a party to the petition, have a duty to bring to the attention of the court. That obligation even becomes more pronounced when it is realized that a substantial number of first respondents counsel are members of the inner bar who even have greater responsibilities to the court by virtue of their ranking. This preliminary objection, like the argument of the petitioners, is therefore rejected. 543. Coming now to the merits of the application, it is common ground that the provisions of the Electoral Act most relevant to the resolution is paragraph 16 of the first schedule. We reproduce it. This provision, with the employment of the word shall, forbids the addition of new facts, especially if such new facts may have the effect of tending to amend or even just adding to the contents of this petition. We cited cases, and I think we have spoken on it in 03. Incidentally, this paragraph also reflects in the case of this sin only restates the well-settled position of adjective law that the claimant's claim or grievance are made in a statement of claim or petition as the case may be, and not in his reply to the statement of claim to that claim, statement of defense to that claim. That position also finds expression in Olubodu and Lawal. We cited what the Supreme Court said there, where it said a plaintiff must not in his reply make any allegation of fact or raise any ground of claim different from what is contained in the statement of claim. If a plaintiff does such a plea is irretrievably bad, and no evidence would be admissible in his proof, end quote. In fact, that settled position of the law is that except in some well-defined situations, a reply to a statement of defense is not even permitted where no counterclaim is served. This is so because there is in law an implied joinder of issues on any fact raised in the statement of defense, and any averment contained therein is deemed denied, cases cited. As to what will amount to a new issue, we cite again Egesimba versus Nuzurike, earlier cited in appeal number 03. Guided by all these and paragraph 16(1)(a) of the first schedule, it does not by any means appear to me that the new facts of conviction, conviction/fine, forgery, and dual citizenship of second respondent introduced by petitioners into their reply. The additional averments of how results could not have been uploaded to INEC's IREV after the 25th of February, and C, whether it was done at all and relevant officials of INEC could not have been involved in it. Not to talk of the repetitions reply of averments already made by petitioners in their petition can pass as reply filed pursuant to paragraph 16(1)(a) of the first schedule of the Electoral Act, particularly as relates to the further details as are quote and unquote, as petitioners labeled them in their reply, of non-qualification of second respondent contained in paragraph 2(1)(b) of their reply. It bears reiterating that all that the petitioners revert to in paragraph 146 of their petition is the bare statement that, quote, the petitioners aver that second respondent was at the time of the election not qualified to contest the election, not having the constitutional threshold, unquote. No details whatsoever was given by them of what they meant by second respondent's non-qualification. So first respondent, who was obviously satisfied that second respondent was qualified to contest the election by the documents he presented to it, also simply joined issues with them in a similar general manner. It is now through their reply that petitioners, who themselves seemed to have had no clear idea of what they meant by second respondents' non-qualification for the election, or simply deliberately kept it back when filing their petition, want to now introduce through their reply at a time when respondents have no further right of responding to them. Such unfair tactics cannot and is not allowed by our law. It must be noted, too, that under Section 131 of the 1999 Constitution of this country, there are as many as 4 different qualifications a person must possess before he can contest presidential election, and another 10 different grounds that can qualify such a candidate who has all the 4 qualifications of Section 131. Therefore, an assertion that merely says that a person is not qualified to contest election by reason of non-qualification will leave not just the person so assailed, but every other person involved, including the court, at a loss as to what the pleader has in mind. In fact, to allow such pleading will amount to upsetting the very essence of filing pleadings in a case, which is to give the adversary and the court a clear notice of the pleader's case, a point further fortified in paragraph 61A of the first schedule to the Electoral Act. Still on this issue, I must not fail to point out that the petitioners were only being clever by half when they claimed in paragraph 21B of their reply that they were simply given, as they put it, further details, quote and unquote, of the non-qualification of second respondent by averring to the conviction, fine, certificate, forgery, and dual citizenship of second respondent that they raised in their replies. They had never given any details of second respondent's non-qualification, and so cannot talk about further details, quote and unquote, let alone hide under such further details to smuggle in the new facts they averred in paragraph 1B of their reply. These new allegations are not also mere, as they call it, evidence in support of their ground of his non-qualification, as their counsel also tried to make them out. They are facts which can only be contained in the petition itself, and not in the petitioner's reply to respondent's defense to the petition. Paragraphs 2(1)b and c of the reply, where petitioners are vowed to no uploading of polling unit results by first respondent, presiding officer at the election, we also agree with first respondent, are new issues, or at least mere further denials by the petitioners to respondent denials of the petition. Such is not also permitted in the reply. See again Bakar and another versus Ibrahim, Akeredolu versus Akinremi, Egesim versus Onuzurike, Spasco versus Alrain, Ishola versus LGBN, or both versus CBN. In the light of all the foregoing, the 2 witness statements as well as list of documents accompanying that reply, all of which were based on the new facts contained in the impugned paragraphs of reply in issue, are also incompetent and liable to be struck out. In summary, first respondents' applications of 9th May succeed in its entirety. Accordingly, paragraphs 1, 2, we stated them of the 1, 2, Roman figure 1, Roman figure 2, Roman figure 3, Roman figure 4, Roman figure 5, and 2(1)b, 2.1b, c, and d of the petitioner's reply, filed in response to the reply of first respondent, together with the 2 witness statements on oath and list of documents which accompany that reply, are all hereby struck out. Second respondent's application seeking striking out his self-respondents. Learned counsel, he also made his arguments, our arguments, and then we come straight to the resolution. And I said here, my Lord said here, that I'm not even in the least persuaded by the argument of the petitioners, that they simply reply to new issues raised by second respondents in reply to their petition. The petitioners, like they did in their reply to the reply of first respondent, introduced fresh facts and issues of non-qualification of second respondent on grounds of his alleged criminal conviction, forgery of documents, and dual citizenship. That is foul play, which paragraph 16 sub 1A to the first schedule of the Electoral Act expressly forbids. Consequently, paragraphs 1B, 1, Roman figure 7, A, B, C, and Roman figure 8 of part 1, as well as paragraphs 2, 3, Roman figure 1, 2, 3 of part 2 of the reply of petitioners. The second respondent, wherein petitioners avert new facts of purported criminal conviction for future proceedings against second respondent adverse to his purported dual citizenship or grounds of non-qualification, are all hereby struck out. Paragraphs 8, 11, Roman figure 1, 24, and 24b of the petition we hold on the state of the authorities earlier considered, are also new facts, or at best mere denials, and so liable to be struck out too, as they do not qualify as replies. Bearing the above, all other paragraphs of the petition filed on the 23rd, petitioner's reply filed on the 23rd of reply 2023 stand either not objected to, or the complaints against them are not made out. In other words, the application of second respondent also succeeds partly as stated above. Third respondent's application as relates, now we come to the third respondent's application, and we come straight to say that I find necessary to first observe that, like all other replies of the petitioners, the impugned reply of petitioners of 24 that was served on third respondent is in parts A and B. Part A is devoted solely to the preliminary objection raised by third respondent's reply to the petition. That part is understandably not challenged by third respondent, so it shall remain as it is. It is only part B of that reply that is challenged by third respondent, and it's also this part that contains in its paragraphs 32 and 33 the fresh facts of second respondent's alleged status as ex-convict and having dual citizenship, all of which now insist disqualified him as a candidate for the election. These facts I have already determined can only be raised in the petition and not in their reply to the respondent's reply to their petition. They therefore offend paragraph 16A stated above. Besides these two paragraphs, every other amendment in paragraph 2 of the reply, bar last paragraph 35, are, as third respondent's counsel rightly pointed out, either mere denials of third respondent's reply to the petition or repetitions of petitioners' amendments in their petition, and so not permissible in a reply as per paragraph 16AB, 1A of the first schedule of the Electoral Act. See again the cited cases. It's also not the law, as erroneously argued by petitioners' counsel, that failure to reply to facts averred by third respondent in his reply to the petition would mean admission of those facts. And somehow counsel like arguing always like that, not just this one. Failure to deny averments contained in a statement of defense does not imply admission, like it does with failure to deny averments in a statement of claim. See again Simba's case, Ayola GSC, I cited this thing. In summary, third respondent's application succeeds in its entirety. Consequently, barring paragraph 35, the entire part B of the reply of the petitioner's reply of third respondent is incompetent and is hereby struck out. That concludes and settles all 7 applications trust preliminary objections of respondents. So that is it. So I now hand over to my leader, as politicians who want to call it, so that my Lord can continue to take over from there.
We'll go to the respondents' objections to documents tendered by the petitioners at the trial. My learned brother, by my immediate right, will read the ruling.
Right. Thank you. We want to take on the respondents' objections to documents tendered by petitioners at the trial. In the course of the hearing of this petition, objections were raised by the 3 respondents. First, to the validity of the witness statements on oath deposed to by some of the witnesses of the petitioners. Specifically, PW12, that is petitioner's 12th witness, Eguma Friday. PW13, that is Grace Timothy. PW14, Grace Ajagbona. PW15, Abidemi Joseph. PW16, Ms. Edosa Obasa. PW17, Ms. Aleri Ayuba. PW18, Ms. Sadia Mohamed Haruna. PW21, Mr. Samuel Odunta, a statistician. PW23, Janet Nuhu Turaki. PW24, Christopher Bulus Ado. PW25, Victoria Sani. PW26, Hitler Egwonu Nwala, a forensic expert. And PW27, Mr. Mike Enahoro Eba, a legal practitioner. These are those who witness statements. Witness statements were filed or deposed to long after petition was filed, and so did not accompany the petition as required by paragraph 45B of the first schedule to the Electoral Act 2022. That is stating that election petition shall be accompanied by a list of the witnesses that the petitioner intends to call in proof of the petition. This objection was argued comprehensively by counsel to parties, and the ruling on it deferred by the court till final judgment. Objections, therefore, were also raised by the respondents to virtually all the documents tendered by the petitioners in proof of their petition. But unlike the earlier objection on witness statements, counsel only gave notice that they will give reasons for those objections in their final addresses. They have since fulfilled their promise by filing separate addresses on those objections. The petitioners, on their part, also objected to some of the documents tendered by the respondents in the course of their defense and gave notice that they will also give reasons for their objections in an address to be filed at the close of the evidence. They, however, seem to have had a change of mind and have not filed any written submissions as promised. I am therefore left with only the objections of the respondents. I now proceed to consider the said objections of respondents. 1. The validity of witness statements on oath of PWs, that is petitioners' witnesses, number 12, 13, 14, 15, 16, 17, 18, 21, 23, 24, 25, 26, and 27 that did not accompany the petition as required by paragraph 45B of the first schedule to the Electoral Act 2022. This objection was taken and comprehensively argued by First Respondents Council on 8th of June 2023, when PW12, Mr. Eguma Omachono Friday, a presiding officer in the disputed 25th February 2023 presidential election, tried to adopt his witness statement on oath, which he deposed only on the 5th, which he deposed to only on 6th of June 2023, long after the petition was filed on 21st March 2023. Subsequently, when the petitioners called their witness numbers 13 to 18, 21, 23 to 27, who also only deposed to their witness statements in the same June 2023, long after the filing of the petition and even after hearing of the petition had commenced, Respondents' Council again raised and adopted the same objections against those witnesses and their witness statements. As explained earlier, the thrust of the objection, which was championed by Chief Wale Olanikwekwe SAN for second respondent, was anchored on paragraph 45B of the first schedule to the Electoral Act 2022, requiring that the election petition shall be accompanied by, among others, witness statements on oath of the witnesses the petitioner intends to call in proof of the petition. Learned Counsel argued that insofar as the witness statements on oath of the said witnesses of the petitioners did not accompany the petition of petitioners as required by paragraph 45B and 6, sub 6 and 7 of the first schedule to the Electoral Act, they were incompetent and cannot be relied on by petitioners or the witnesses concerned. It is irrelevant. Counsel argued that the said witnesses came to testify on subpoena issued to them by this court as paragraph 45B of first schedule to the Electoral Act makes no distinction between ordinary witnesses and those who were testifying on subpoena. Then that argument was taken, and after hearing the argument, this is our resolution. Now, this contention of the respondent has far-reaching consequences, as its resolution in favor of respondents will result in the court discountenancing the evidence of all the presiding officers, namely PW 12, 13, 14, 15, 16, 17, 18, 23, 24, and 25, who were in the polling units in the election, and so were eyewitnesses to the alleged failure by INEC to transmit and uphold the election results to IREV, a major pillar of the petition. It will also result in discountenancing the evidence, oral and documentary, presented by petitioners' two expert witnesses, PW 21 Samuel Odunton and PW 26 Hitler Egwonwala, but also their last witness, Mike Enauro-Eba, PW 27, who alone testified on the non-qualification of second respondent for the election and tendered documents in that direction. That is, even as we must not fail to remind ourselves that the relevant facts in the petition and replies of the petitioners that would have supported the evidence of PW 21, 26, and 27, Mr. Samuel Odunton, Hitler Egwonwala, and Mike Enauro-Eba, have already been found incompetent and struck out by this court while ruling on the applications preliminary objections of the respondents. Coming back to the objection of the respondents that paragraph 45B of the first schedule to the Electoral Act 2022 does not make any dichotomy between ordinary witnesses and those testifying only on subpoena as regards the duty to front-load witness dispositions along the petition. So the evidence of PW 12, 13, 14, 15, 16, 17, 18, 21, 23, 24, 25, 26, and 27, whose witness statements or notes were not front-loaded with the petition are incompetent. Paragraph 45B of the first schedule to the Electoral Act 2022 reads thus, and I want to mention it. It says the election petition shall be accompanied by B, written statements on oath of witnesses. And clearly, this provision, particularly the word witnesses, whose written statements on oath the lawmakers require that shall accompany the election petition, must be given its literal interpretation. See the recent decision of this court in Ogba and Vincent, and then that of Senator Ararumi and INEC, all citations supplied. The unreported decision of this court also of 17th of July 2020 in Advanced Nigeria Democratic Party ANDP versus INEC and two others, appeal number EPT 406/2020 and People's Democratic Party versus Okogbo, citation supplied on the issue. Where the words of a statute or instrument are clear, like paragraph 45B of first schedule to the Electoral Act is, particularly the unqualified witnesses, in quote, employed there, the court has no duty than to give it its literal meaning. Now, in Advanced Nigeria Party, Democratic Party NPO versus INEC, in appeal already cited, presided over by Justice Igenimpa and Agim, our colleagues, as Agim as he then was unanimous in his decision on the point in issue. IGJCA, pronouncing the leading judgment, said, I am of firm view that if Section 145 of the Electoral Act 2010 and paragraph 54 of the first schedule to the Electoral Act 2010 are juxtaposed with Order 3, Rules 2 and 3 of the Federal High Court Civil Procedure Rules 2019, it is eminently clear that Order 3, Rules 2 and 3 of the Federal High Court Civil Procedure Rules is outrightly inapplicable to the situation the appellants find itself in this case. Paragraph 3 and 4 of the first schedule to the Electoral Act 2010 contain express and adequate provisions as to what the contents of a petition should be and the documents that must be front-loaded and accompany an election petition, including a list of witnesses that the petitioner intends to call, improve of the petition, and more importantly, written statements on oath of witnesses. Well, there is also, it says further, there is no dichotomy between witness statement mentioned in paragraph 4.5 of the first schedule to the Electoral Act in respect of witnesses' statement on oath of witnesses and witnesses' statement on oath of a subpoena witness. There is no distinction between ordinary witness and subpoena witnesses under paragraph 4.5 of first schedule to the Electoral Act. In essence, paragraph 4.5 of first schedule to the Electoral Act covers witness statements on oath of all categories of witnesses the petitioner intends to call at the trial of his or her petition, unquote. In Senator Ifeanyi Ararume and INEC, this court also, presided over by my Lord Justice Samani JCA, the concurrence of my brothers Owade Akimbami, Balaji Yusuf, and Bayero JCA, again confirmed this position when, in that decision, it was held. Learned counsel for the appellant has argued that PW2 was before the court on subpoena, therefore the tribunal could not turn around to prevent him from testifying. It is not disputed that the said witness was before the court on subpoena ad testificandum, but it must be realized that the witness was subpoenaed on the application of the appellants. He was not summoned by the tribunal in the exercise of their powers pursuant to paragraph 41, 5, and 6 of the first schedule to the Electoral Act. He was therefore, for all intents and purposes, witness for the appellants. In that respect, his written statement or note was subject to the requirements of the law as stipulated by paragraph 4.5 of the first schedule. Strict compliance with paragraph 4.5 of the first schedule to the Electoral Act is mandatory. It is of such a nature that there is sanction in subparagraph 6 of paragraph 4. This point was also earlier made in petition 03. Also see the decision of PDP and Okabwe, and then Ogba and Vincent, Midira and Patricia Ete, Awoyemi, Lasun and Awoyemi. All these cases have their citation here, and they already referred to in our earlier 3. Okay. It is of interest that in all these cases, the earlier decisions of this court, Midira versus Patricia Ete and another, and Lasun versus Awoyemi, relied on strongly by Mr. Chris Uche, SAN, for the petitioners were cited and considered but departed from by this court. Quite remarkably too, in his book, Modern Nigerian Election Petitions and Appeals Law, published in November 2017, which book Chief Chris Uche, SAN, the lead counsel for petitioners herein, wrote a glowing forward to. The learned author, Mr. Kelechi Peter Ikoroga, Esquire, had this to say at pages 134 to 140 while commenting on this same issue, the SR position of this court in Omidira and Ete, and then Lasu versus Awoyemi. There, Chief Uche, SAN, who is incidentally is present here, says, just like a petitioner in an election has 21 days from the date of the result of the petition to file his petition, otherwise such a petition becomes statute bar, there is also a time limit to the period within which a petitioner is to file a deposition or other document not filed along with the petition. Thus, all evidence required in proof of a case must, as a precondition to exercise jurisdiction, be brought within the stipulated time frame. That is to say, 21 days after the declaration of the result. The Supreme Court has consistently, in the long line of cases, insisted on this strict and inelastic approach in enforcing the electoral laws. Thus, the efficacy of the decision of Omidirong versus Ete, see also Lasso and Awoyemi, citation supplied, wherein the Court of Appeal held that it would be appropriate to meet the justice of the case for a tribunal to order the filing of witness depositions by subpoenaed witnesses outside the stipulated time frame has been watered down, in that all evidence required in proof of the case must be brought within stipulated time frame. See the case of Ogba and Vincent, where the Court of Appeal, Agim JCA, as it then was in lead judgment, held, I think that this court in Omidira and Ete and the Supreme Court in Oke and Mimiko adopted different approaches in addressing the issue of whether a tribunal or a court can allow a witness deposition or other document not filed along with the petition or not filed within the time allowed for filing election petition to be filed and used in an election proceeding. Omidiron's case did not strictly enforce the time limits prescribed in Section 141 of the Electoral Act 2006, the provisions in the first schedule thereto in prohibiting the introduction of additional facts in the proceedings after the period allowed for filing the petition and closure of pleadings, and paragraph 1 of Election Tribunal and Court Practice Direction 2006, and the content and form of the petition. It held that the purpose of the practice direction is to guide and regulate compliance with and observance of the provisions of the first schedule to the Act and the Federal High Court rules where applicable. This elastic approach of the electoral laws by this court in that case is not in line with the current judicial approach of strict enforcement of electoral laws and the current approach of applying the election tribunal, and court practice directions in the rules of court in election cases. In Oke versus Mimiko, the Supreme Court approached the issue in keeping with the current judicial trend of strictly applying electoral laws and procedural rules and giving them supremacy over rules of court in election cases. The law has laid out strictissima juris in Oke and Mimiko is that a witness deposition that is not filed along with the petition within 21 days allowed for filing the petition cannot be filed in the proceedings. It held thus: if there was evidence which was fundamental to the determination of the petition, that evidence ought to have been placed willy-nilly before the tribunal within the time specified by the Electoral Act or any other act. That evidence ought to be regarded as the spinal cord of the petition, even if it was being withheld by any person. There are several ways to go about placing same before the tribunal. The Evidence Act is very clear on this, and the petitioner ought to have resorted to that procedure. Put this in italics. We have earlier mentioned it in 03. As earlier said, Chief Chris Uche, SAN, in his foreword to that book, glowingly endorsed this author's position and even recommended it to judges like us in these words: the author has ably and remarkably sought to examine the legal framework of electoral legislation within the landscape of judicial decisions emanating from disputes arising from elections in the context of election litigation, from the preparation of the election itself through the pre-trial proceedings, the actual trial, the judgment and trial proceedings. This book truly stands out in the midst of several other books in this field. As an avid participant in electoral litigation, I wholeheartedly recommend this book to all, particularly to lawyers, judges, students of electoral laws, litigants, and as well as all stakeholders in the development of our constitutional democracy, unquote. I shall hold counsel to his words, not just because they are coming from him, but also because they are correct. Permit me to still say a word or two on petitioners' contention that Order 3 Rules 2 and 3 of the Federal High Court Civil Procedure Rules 2019, permitting parties to file witness deposition of a subpoenaed witness even after commencement of the action, applies automatically to election petitions by virtue of paragraph 54 of the first schedule to the Electoral Act 2022. So witnesses' statement, they said, of their witnesses filed by them after hearing of the petition had long commenced wherein were in order. Full stop. In the first place, paragraph 54 of the first schedule to the Electoral Act simply states, subject to the express provision of this Act, the practice and procedure of the tribunal or the court in relation to election petitions shall be as nearly as possible similar to the practice and procedure of the Federal High Court in the exercise of its civil jurisdiction, and the civil procedure rules shall apply with such modification as may be necessary to render them applicable, having regard to the provisions of this Act, as if the petitioner and the respondent were respectively the plaintiff and the defendant in an ordinary civil action. This provision clearly makes application of the civil procedure rules of the Federal High Court in election petitions subject to the express provisions of the Electoral Act. It is not the other way around of modifying provisions of the Act to agree with the rules of the Federal High Court as suggested by Petitioner's Counsel. That much, paragraph 54 further clarifies by stating that even where the Federal High Court rules are considered applicable, they shall only apply with such modifications as may be necessary to render them applicable, having regard to the provisions of this Act, unquote. What all that means is that where there is express provision in the Act on a particular situation, such as it clearly is in paragraph 45B of the first schedule to the Electoral Act 2022, that says the election petition shall be accompanied by written statements of oath of witnesses, the provisions of the Federal High Court Civil Procedure Rules will not apply. Fortunately, there is again high authority in support of this position in the dictum of Muntaka Kumasi GSC in Nwankwo versus Yaradua, citation supplied, where His Lordship, after producing paragraph 50 of the first schedule to the Electoral Act, now paragraph 54, had this to say. Say from the above, it is crystal clear that the provisions of the Federal High Court rules are subject to the provisions of the first schedule of the Electoral Act 26, and if there is any conflict between them, the provisions of the rules under the Electoral Act will prevail. It is where there is a lacuna in the provision of the rules provided in the Electoral Act 2006 that the provisions of Federal High Court rules will apply. I shall also add that the Parliament have expressly stated without dichotomy in paragraph 45B of the first schedule that to the Electoral Act that petitioners shall front-load witness statements of their witnesses along with their petitions. It is not within the province of the court to give that provision a different interpretation. It is also no moment that in the court's opinion, the say literal meaning of paragraph 45B of the first schedule to the Electoral Act 2022 seems harsh and may not meet the justice of the case, as is being suggested by the petitioners that subpoena is only issued to an unwilling witness, so it is not contemplated by paragraph 45B of the first schedule to the Electoral Act 2022 that a witness on subpoena should also depose to a witness statement before the subpoena to compel the attendance is served on him by the court. If anything, the argument rather brings to mind the very strong admonition of the British House of Lords Lord Denning MRL in Duport Steels Limited versus SIRS, citation supplied, where the learned Lord Scammon in his speech said, "But in the field of statute law, the judge must be obedient to the will of the Parliament as expressed in its enactments. In this field, Parliament makes and unmakes the law. The judge's duty is to interpret and to apply the law, not to change it to meet the judge's idea of what justice requires. An interpretation does, of course, imply in interpreter a power of choice where different constructions is possible, but our law requires that the judge chooses the construction which, in his judgment, best meets the legislative purpose of the enactment. If the result is unjust but inevitable, the judge may say so and invite Parliament to reconsider the provision. But he must not deny the statute. Unpalatable statute may not be disregarded or rejected merely because it is unpalatable. Only if a just result can be achieved without violating the legislative purpose of the statute may the judge select the construction which best suits his idea of what justice requires in any case. That is a settled position of the law, even in this country. See Ndomaegba and Shukwogo. Citation supplied. Aromolaro versus Agoro. Coca-Cola Nigeria, Akinsanya, then Global Excellence, cited earlier, and Donald Duke. There, summarized aptly, wherein my Lord said, the duty of the court is not to deal with the law as it ought to be, but as it is. Paragraph 45B of the first schedule to the Electoral Act 2022, I will even venture to say further, appears to have been inserted by Parliament in further realization of the sui generis time-bound nature of the election proceedings, a point further driven home by the Constitution of the Federal Republic of Nigeria, Second Alteration Act 2010, which introduced, among others, a new Section 285 sub 6 into the 1999 Constitution. That provision states that an election tribunal or court shall deliver its judgment in writing within 180 days from the date of filing of the petition. This time limit for disposal of proceedings, it must be noted, is peculiar to election petition proceedings in our body of laws. It is not found in any other proceeding in the entire body of laws of this country. It thus imposes on the election court or tribunal a duty to properly utilize its case management through pre-hearing session as effectively as possible to carefully plan the future course and particularly its plenary hearing of every petition so as not to fall foul of the maximum 180 days limit. That necessarily includes trimming the number of witnesses where necessary once pleadings are closed in the petition. That is also the point echoed by this court in People's Democratic Party and Chibuzo, Okogbu, and others, citations supplied, where my colleague Abadwa JCA said, what is deducible is that witness deposition filed by a witness not listed in the petition cannot be countenanced by the court or tribunal after the expiration of the time prescribed for the filing of the petition. It was stressed also by this court hearing that to to allow a petitioner to file an additional witness statement at any stage of the election proceedings would destroy the regulated environment that must exist to ensure that both parties to the petition are expeditiously heard and the petition determined within 180 days from the date of the petition. This court observed that such an indulgence will remove the control of the pace of the proceedings from the control of the Constitution, the Electoral Act, and the first schedule to the Electoral Act, and leave it at the whims and caprice of the parties, and open the floodgates for all kinds of abuses of the judicial process, unquote. I think the same point is also deducible from the following. In the dictum of Toby mentioned similar things in Buhari and INEC, and then Buhari and INEC also said a lot about that. We have mentioned it earlier. And then by rules of stare decisis, the decision in Oke and Mimiko and Ogba Vincent, decisions of this court is bound not only by decisions of the Apex Court, but also by its own previous decisions. And these are known issues. Victor Rusek and ACB is there, and then ITPP Limited and UBN Limited. See the decision of Ogbuagu GSC. Long and short of all the foregoing is that the objection of the respondents to the witness statements of PW12 Eguma Friday, PW13 Grace Timothy, PW14 Grace Ajagbona, PW15 Abidemi Joseph, PW16 Ms. Edosa Obosa, PW17 Ms. Aleria Ayuba, PW18 Ms. Sadia Mohamed Aruna, PW21 Mr. Samuel Odunta, the statistician, PW23 Janet Nuhu Turaki, PW24 Christopher Bulusado, PW25 Victoria Sani, PW26 Hitler Ewonu Nwala, forensic expert, and PW27 Mr. Mike Enaoroeba, legal practitioner, which did not accompany the petition as required by paragraph 45B of the first schedule to the Electoral Act is hereby sustained, and the witness statements being incompetent are hereby struck out and expunged from the records of this court. The further consequence of that decision is that, given the provision of paragraph 41 sub 3 of the same first schedule to the Electoral Act 2022, stating that there shall be no oral examination of a witness during his evidence in chief except to lead witness to adopt his written deposition and tender in evidence all disputed documents or other exhibits referred to in the deposition. It follows that all the evidence, including evidence in cross-examination and all documents, reports included, namely PAH1, PAH2, PAH3, and PAH4, and PAR1A, PAR1B, PAR1C, PAR1D, PAR1E, and PAR1F, and PBD, PBD1A, PBD1B, PBD1C, PBD1D, PBD1A, PBD1A, PBD2A, PBD3, PBD4, PB1, PBE2, PBE3, PBE4, PBE5, PBE6, PBF1, PBF2, PBF3, and PBF4, coming from and tendered by the said petitioner's witnesses, namely, as I already listed, PW 12, 13, 14, 15, 16, 17, 18, 21, 22, 23, 24, 26, and 27 aforementioned are incompetent and are hereby expunged from the records of this court. Other objections of respondents. That takes me to the other objections raised by the respondents to the admission of documents tendered by petitioners at the hearing, which objections they only gave notice that they will give reasons at final address stage. All three respondents filed their submissions on the objections and adopted them on 1st of August 2023. Petitioners on the same 1st of August also adopted their responses to those objections. Now, before going into the objections, we deem it necessary to first dispose of the preliminary argument of counsel to petitioners that some of the documents objected to by respondents are electoral material certified by the first respondent INEC, which documents Parties had agreed at the pre-hearing session that they will not object to, so respondents cannot resile from that agreement and raise objection as they are doing. They even cited Section 169 of the Evidence Act 2011 to say respondents are stopped from resiling from that agreement. The simple answer to that argument is that this court, and indeed every court, is bound to act on only admissible evidence. So if a document or piece of evidence is inadmissible in evidence, the court must expunge it, and it must do so even if that will require it to overrule its own interlocutory decisions admitting that evidence. See Shano and AfriBank and other authorities in that respect. As counsel, as ministers in the Temple of Justice, are therefore within their right and in fact duty-bound to draw court's attention to that fact, regardless of whatever agreement they may have had with petitioners at the pre-hearing session. In any event, the court is only bound to honor lawful agreements, not unlawful ones, to admit evidence that may well be inadmissible. With that said, I now proceed to the objections as contained in the addresses filed by respondents. Here, I shall take them together as I would have done if reasons now advanced for them were canvassed earlier. Now, let's look at first respondents' alleged allegation of improper or non-certification of INEC documents. Counsel to the first respondent in paragraphs 1.34 to 1.36 of first respondent's written address filed on 14th of July 2023, second respondent at paragraph 3.13 of his 20th of July 2023 address, and third respondent in paragraph 1.14 of his written address on objections filed on 14th of July 2023, all argue that that payment for certification is one condition precedent under Section 104 of the Evidence Act 2011 for certification of public documents. They said petitioners did not pay for certification of some INEC documents, specifically exhibits PAJ1, to PAJ37, PAJ38, PAJ39A to F, PAJ40, PAJ41 to PAJ and PAJ41 to PAJ7. There's something wrong. PAK1, PAK13, PAL1, PAL2, PAQ to PAQ14, exhibits PAS1 to PAS20, exhibit PAT1 to PAT17, then PAU1 to PAU17, PAV to PAV20, PAW1 to PAW25, PAX1 to PAX13, PAY1 to PAY18, PAZ1 to PAZ17, PBA17 to PBA27, PBB1 to PBB21, and did not provide any evidence of payment of certification fees. Learned Counsel, all citing the cases of Tabik Investment and GTB, Jimon, Minister of Federal Capital, Emeka and Chuba Ikpeazu, argued that certification fees for the said documents having not been paid by the petitioners, the documents remaining admissible and liable to be expunged from the records. Petitioners in response argued in paragraph 4.1 and paragraph 6.0 to 6.2, paragraph 2.123 of their response to second respondent, and paragraph 2.16 to 2.7 of their response to third respondent, that they actually paid certification fees to first respondent for their said documents, and that they were issued receipts by the first respondent. Some of those receipts, they said, were attached to the documents themselves, while others were separately receipted for, including, in one instance, payment of 6,669,301 naira 25 kobo, and another for 150,967 naira 50 kobo. They argued that it was therefore unconscionable of first respondent who collected such huge sums of money from them to turn around and plead non-payment of certification fees. Benin Senior Counsel on petitioners' behalf also pleaded the Evidence Act's presumption of regularity of official acts and submitted that it was strange that a public institution like first respondent will come before a court of law to disown documents officially issued by it. In specific response to third respondent's argument, counsel to petitioners argued that Section 1041 and 2 of the Evidence Act 2011 does not prescribe that the amount paid for certification must be reflected on the certified true copy of the document as part of the certification. So the argument of third respondent's counsel that because the certification of the said exhibits did not carry the amount paid for certification fees were not paid for is clearly erroneous. Now, Section 104 of the Evidence Act provides every public officer having custody of public document which any person has a right to inspect shall give that person on demand a copy of it on payment of the legal fees prescribed in that respect, together with a certificate written at the foot of such copy that it is a certified true copy of such document or part of it as the case may be. Secondly, the certificate mentioned in subsection 1 of this section shall be dated and subscribed by such officer with his name and his official title and shall be sealed whenever such officer is authorized by law to make use of a seal, and such copies shall be called certified true copies. There is nothing in the foregoing provision, particularly subsection 2, dealing with what should appear on the certification, that suggests that the fees paid for certification of a public document should also appear on the face of the document, like the date, name, and official title of the public officer issuing the document. As required by subsection 2, payment of certification fees is only a condition precedent to the certification. So it could be stated in any other place, including another document. That point, this court also made plain in answer to a similar argument in Dagash and Bulama. And see also Uzoman, Sodike, ANPP, and PDP, all these were made clear there, where it was held that certification in fee contained in separate document is sufficient. In this case, not only is there evidence of certification fee payment by petitioners first in the form of SBPD, showing payment by petitioners to INEC of the sum of 150,967 naira 50 kobo for some documents. There is also a second INEC receipt in INEC's own letterhead and attached to Exhibit PAF 4C. This latter document evidencing further payment of certification sum of 6,696,301 naira 50 kobo by the petitioners, Atiku/PDP legal team, shows that it was made via receipt number RRR 270-842-653235 and on INEX receipt number 069727 of 25th of May 2023. It specifically states on its face thus: a sum of 6,696,301 naira 25 kobo only, being payment for CTC IPO electronics of a copy of data level number data level, although not very legible, with time, then stamp, event history, polling units of EC8As and S yet to be uploaded from EC9 and other documents 2023 presidential election unquote. All that, in my opinion, is sufficient evidence of certification fee payment. Even more so, when the receipt indicates that the said payment also covers other documents outside those specifically mentioned therein. The burden had thus shifted to the first respondent INEC to show that the monies it received from petitioners for certification fee payment did not cover the documents they are now talking about, which documents INEC interestingly also certified. That burden INEC never discharged, especially when account is taken of the fact that he did not even give the amount assessed, if any, that petitioners were owing them for certification. By the provisions of Section 104(1) of the Evidence Act, an applicant for certification of public document is only obliged to pay what is assessed by the public officer. What is more, the mere fact that respondents certified the said documents for petitioners, coupled with the evidence of certification fee payment by petitioners in Exhibits PD and PAF 4C, sufficiently triggers the provisions of Section 168(1) of the Evidence Act 2011 that says when any judicial act or official act is shown to have been done in a matter substantially regular, it is presumed that formal requisites for its validity were complied with. This ground of the objection is therefore overruled. Then on the issue of alleged engravement of certification, it was also argued by the respondents relying on Belgore and Ahmed that certification of the same documents was done by public officer of INEC by engravement of his name, official title, and date instead of subscription, so that also, he said, is invalidated the documents and rendered them inadmissible. I've carefully perused the said documents and verified that unlike Belgore and Ahmed, the documents in issue here bear the long-hand signature of the relevant certifying public officer of INEC. That, in our opinion, is substantial compliance with Section 104 of the Evidence Act and attracts the presumption of genuineness via Section 146 of the Evidence Act. First and second respondents in particular also argue that exhibits PAH1, PAH2, PAH3, and PAH4 tendered by PW21, Mr. Samuel Odunta, and exhibit PAR-A to F tendered by PW26, Mr. Hitler A1 Mwala, were made during pendency of this proceeding or in anticipation of it, and therefore inadmissible in evidence by virtue of Section 83(3) of the Evidence Act 2011. In their response, the petitioners argued that the said documents were made pursuant to the orders of this court, pursuant to Section 146(1) of the Electoral Act 2022, permitting them to inspect documents, so they were properly before the court. Much as I am not oblivious of our earlier ruling, that these same documents coming from witnesses whose witness statements on oath were not front-loaded with the petition are incompetent and so already struck out, I am also of the opinion that the petitioners seem to 595 seem to completely misconceive the objection raised by the respondents, which is to the effect that the said documents, having been undeniably made during the pendency of this petition or in anticipation of it, are rendered inadmissible by the principal law guiding admissibility of evidence, the Evidence Act 2011, and Section 83 thereof, sub 3 thereof. It is therefore lame of the petitioners to find their breach of that provision on account of the orders of this court made pursuant to Section 146(1) of the Electoral Act 2022, that they be allowed to inspect polling documents in the custody of INEC. In any case, Section 146(1) of the Electoral Act 2022 merely states that an order for inspection of a polling document or any other document or packet in the custody of the Chief National Electoral Commissioner or any other officer of the Commission may be made by an election tribunal or a court of competent jurisdiction if it is satisfied that the order required is for the purpose of instituting, maintaining, or defending an election, unquote. This does not in any way give petitioners the leeway to adduce evidence in breach of Section 83, sub 3 of the Evidence Act 2011. Section 146 of the Electoral Act 2011 and the interim orders of this court only permitted the petitioners to inspect election documents for the purpose of instituting or maintaining an election petition. Nothing in that provision allows a petitioner to file evidence, let alone the bulky expert reports as in exhibits PAH1 to 4, PAH1AF, PAR1A to F, during the pendency of the petition. The whole idea behind Section 83(3) of the Evidence Act 2011 is to eliminate the danger inherent in allowing a party to manufacture and bring in evidence specifically tailored in anticipation of a case, or was to produce such fresh evidence after the case had begun and parties had fully joined issues in it. That is exactly what the petitioners sought to do with exhibits PAH 1 to 4 and PAR 1 A to F, prepared and filed by experts long after pleadings in the petition had closed, when respondents will no longer have opportunity of retaining their own experts to respond to the evidence presented against them in the said reports. I'm in agreement with the respondents and hereby uphold their objection that the said reports, which were admitted in evidence as exhibits PAH1, PAH2, PAH3, and PAH4, and PAR1A, PAR1B, C, D, and E, and F are without prejudice to our earlier decision that the incompetent is also rendered inadmissible in evidence by virtue of Section 83, sub 3 of the Evidence Act 2022. Oh, sorry, Evidence Act 2011. Then the next one is inadmissibility of election documents tendered as exhibits by petitioners on grounds of absence of pleading to support them and consequential irrelevance to the petition. The respondents' argument here are given, so we'll now skip that to the resolution. We've seen that, and the resolution we have it appears clear to me that the respondent's objection here is misconceived and founded on isolated reading of paragraph 143 of the petition, where the petitioners aver that the first respondent and his agents wrongly and deliberately entered wrong scores results for the underlisted 22 states, namely Abia, Adamawa, Akwa Ibom, Anambra, Bauchi, Bayelsa, Cross River Delta, Edo, Enugu, Gombe, Imo, Kaduna, Katsina, Kebbi, Niger, Osun, Taraba states. Pleadings, they said, of party is not read in that isolated manner to get at a party's complaint. Pleadings must be read holistically to get at the complaint in issue. If that is done, as it should be done, the respondents would have come across where petitioners left no one in doubt that their complaint about the election is nationwide and not isolated to only some few states. That much is clear. First, from paragraph 107 of the petition, where petitioners averred that the petitioners shall give evidence to show that the election results.
In the pleadings from paragraphs 128 to 142, avert to issues of violence and disruptive activities. These allegations are criminal in nature. The standard of proof where an allegation of crime is made in an election petition is proved beyond reasonable doubt and not on the balance of probabilities. See Emmanuel and Umana. A complaint of massive suppression, deduction, and allocation of votes connotes forgery or fraud, particulars of which must be pleaded and proved beyond reasonable doubt. See Kaki and PDP and others, Nwobodo versus Ono. First, respondent joined issues with the petitioners' allegations in paragraphs 92 to 142 of the petition. The second respondent and the third respondents, in a similar manner, joined issues with the petitioners in calling on them to prove their claims as required by law. What this entails is that the petitioners who made all these allegations have the burden to prove all their allegations as required by law. The petitioners have placed reliance on the evidence of their statistician and forensic expert, who are PW21 and PW26 respectively. Had time to look at the evidence of these witnesses and had ruled that their evidence, apart from being improperly before the court, is also hearsay. The statistician's report rolled out figures or forms which he claimed were either not signed or stamped, but none of the forms referred to was attached to the report. The polling unit agents of the petitioners, who were present in all the polling units around the country, were not called to testify to any problem or difficulties in their polling units on the 25th day of February 2023 presidential election. That is fatal to the petitioner's case. Thus, in Belgore versus Ahmed, it was said by Taba JSC as follows in the lead judgment. With respect to the volume of documentary evidence, I wish to state at the risk of repetition that they were merely tendered across the bar by Land Council for the petitioners at the trial. He did not and was not in a position to answer questions or otherwise speak on any of them. Their makers were not called. In such circumstances, was the trial tribunal bound to ascribe probative value to them? I shall answer this question in the negative. The trial tribunal had no duty to accord probative value to the mass of documents, their status as certified documents notwithstanding. There is no doubt that the petitioner's decision to tender the mass of documentary evidence at the trial was prompted by the urgency dictated by Section 285(6) of the 1999 Constitution as amended. That, however, does not diminish the petitioner or appellant's burden and standard of proof of the petition. They had a duty to prove their petition according to law, close of court. This position of the law may have been fairly watered down under the current electoral regime by Section 137 of the Electoral Act 2022, stating that it shall not be necessary for a party who alleges non-compliance with the provisions of this Act for the conduct of elections to call oral evidence if originals or certified true copies manifestly disclose the non-compliance alleged. But even at that, it cannot be gainsaid that oral evidence is necessary to explain discrepancies in original or certified true copies of election documents, where the complaint verges on whether an alteration or amendment in an original or certified true copy of a polling unit result was made with intent to falsifying it, or whether it was simply made to correct an apparent human error in the course of making entries in the result. Such situation would surely need a witness to explain or speak to the documents in order to prove falsification of election documents when it is so alleged, as pointed out in Belgole and Ahmed. See also the case of Waziri Ibrahim and Shagari and Buhari versus Obasanjo. All the above, in my view, also explain the rationale for the employment of the adverb manifestly by the draftsman in Section 137 of the Electoral Act 2022. What the word suggests is that the non-compliance complained of must be apparent on the face of the electoral document. It must not be something that can be explained away by oral evidence one way or the other. I have in this judgment explained the issues of evidence of witnesses who were not polling unit agents. The collection agents of the parties who testified were given accounts of stories related to them by people who were not called as witnesses in this petition. The interpretation of Section 137 of the Electoral Act 2022 by the petitioners was generously and swiftly silenced, the otherwise potent adverbial word manifestly used by the legislator in that section of the law. Manifestly is defined by online dictionary to mean in a way that can be readily seen by the eye or the understanding plainly or obviously, evidently, close of court. This means for the petitioners to throw up their arms and say we need not call oral evidence in proving non-compliance as they are conversing. The certified copies of documents presented must be manifestly and readily seen to convey the fact of non-compliance. We have started this approach to Electoral and ANEC for the JSC. From this authority, it is the law that where the documents tendered and relied upon by the petitioners do not manifestly disclose the non-compliance alleged, the petitioners will still need to call witnesses who witness the alleged acts of non-compliance to testify. In the instant case, the petitioners tendered loads of certified copies of the document. The petitioners filed 5 schedules of documents. The first schedule was filed on 30th May 2023. The second was 31st May 2023. The third was 2nd June 2023. The fourth was 7th June 2023. And the fifth was filed on 21st June 2023. From these schedules of documents, a lot of exhibits were generated and tendered. These exhibits were objected to by the respondents. I had earlier in this judgment dealt with the documents and objections. However, I want to have a look at these documents to see if they manifestly show any lack of compliance. These exhibits include the following: exhibits PG, PG1 to PG3, which were the printouts of bimodal voter accreditation system, VIVAS, for Abia, Adamawa, Akwa Ibom, Anambra, Bauchi, Bayelsa, Benue, Borno, Cross River, Delta, Ebonyi, Edo, Ekiti, Enugu, FCT, Abuja, Gombe, Imo, Jigawa, Kaduna, Kano, Katsina, Kebbi, Kogi, Kwara, Lagos, Nasarawa, Niger, Ogun, Ondo, Oshun, Oyo Plateau, Rivers, Sokoto, Taraba, Yobe, and Zamfara were admitted, though objected to. Exhibit PH1 to PH36, which were the annex data on number of registered voters and collected PVCs for the 2023 general elections for the state, listed in the first schedule of documents as numbers 46 to 82 were admitted. The second schedule of documents was filed on 31st May 2023, and the documents listed here Surprisingly, the documents were dumped on the court without any witness linking them up with the specific complaints of non-compliance. It is certain law that despite the tendering of exhibits in proof of a petition, the onus of proving the case pleaded and for which the documents were tendered in evidence lies on the petitioner. In the instant petition, a lot of documents were tendered from the bar. When a party decides to rely on documents to prove his case, there must be a link between the documents and the specific areas of the petition. The party must relate each document to the specific case for which the documents were tendered. Failure to link the documents is fatal and catastrophic, as it is in this case. The Supreme Court, in the recent case of Tumbi Bido versus Anek, have cited the portions. In this situation, it is invariably correct that all the allegations raised in this petition have not been proved as required by our law. See Buhari and INEC, Part 12 JSC. It is also important to draw our minds to the fact that criminal allegations are usually and directly made personal. For allegations of crime to be proved against the respondents, it must be proved that they committed the corrupt acts or aided, abetted, consented to, or procured their commission. Furthermore, it must be proved that the corrupt practices substantially affected the outcome of the election. See Omishore versus Arebeshola. The law also places the onus on the petitioner to demonstrate by credible evidence that the alleged corrupt practice indeed occurred and that it affected substantially the outcome of the election. In that quest, the petitioners pleaded some states where the malpractice allegedly occurred. One of such states is Sokoto State. They placed PW19, PW21, and PW22 to prove the allegations that the first respondent cancelled results from 241 polling units in Sokoto State in respect of National Assembly elections in the state, but went ahead to declare results for the presidential election. The three witnesses, PW19, 21, and 22, were not in Sokoto during the election. There is also no evidence tendered of the cancellation of results in any of the units alleged. PW19 and PW22, when cross-examined, said they were in Kogi State, where they voted and later came to Abuja. The PW21 is the statistician who testified of overvoting, non-signing and cancellation of forms used, but he did not tender or show those compromised forms. The same occurred in their testimonies in Kano State, Kogi State, Lagos State, and River State. From the foregoing consideration, it is very clear that there was no credible evidence by the petitioners to prove the allegations of corrupt practices. Under this issue raised, the petitioners were asking if the first respondent was not wrong in returning the second respondent when he was not duly elected by majority of lawful votes cast in the election. From the facts placed before the court, the first respondent declared the results of the election by which the second respondent was returned. Section 1342 of the 1999 Constitution talks of the highest number of votes cast at the election if the contest was among more than two candidates, as in the instant case, not majority of votes cast as propounded by the petitioners. The first respondent was therefore right from the result declared by her, in the absence of any rival or alternative result placed before this court by the petitioners, that the second respondent, who scored 8,794,722 votes, as against 6,984,520 votes scored by the petitioners in the election, scored the highest number of lawful votes cast in the election. Issue 4 is accordingly resolved against the petitioners and in favor of the respondents. Having resolved all the votes, four issues against the petitioners, I find that the petitioners have successfully proved any of the grounds as laid out in paragraph 16 of their petition. It is my conclusion that this petition also lacks merit. Having considered and decided that the three petitions, number CA from PEPC 03-2023, CAPEPC 04-2023, and CAPEPC 05-23 are all devoid of merit. The petitions are hereby dismissed. Accordingly, I affirm the declaration and return of Bola Ahmed Tinubu by the Independent National Electoral Commission Annex as the duly elected president of the Federal Republic of Nigeria. The parties in the three petitions are to bear their respective costs. So now I will call on my learned brother by immediate right to read his own judgment.
Thank you. Please sit down, sit down. Thank you, my Lord. I was privileged and privy to be part of the decision and the judgment elaborately given by my Lord presiding Honorable Justice Haruna Somani, and I am in full agreement with the lead judgment as delivered by him in these three consolidated petitions, which are petitions number CAPEC 03-2023 and CAPEC 04-2023 and CAPEC 05-2023. I agree also with the consolidated rulings on the various objections and other interlocutory applications relating to the competence of witnesses and the documents tendered in the three petitions highlighted. I also agreed with the reasoning and the conclusions arrived at the rulings on the preliminary objections and the substantial issues raised therein. In any concluded election, there are bound to be a winner and losers While the winner celebrates victory, an aggrieved loser may come before the court to ventilate his grievances. This is made possible by the Constitution of the Federal Republic of Nigeria, 1999 as amended, which in Section 6 thereof empowers the courts to determine disputes, including election disputes. It is well settled that an election petition by nature is sui generis, of its own kind or class. It is not like going to court to make a claim of debt, contract, or tort. It has its own character, and it is unique by its nature. The slightest non-compliance with a procedural step, which otherwise could either be cured or waived in ordinary civil proceedings, could result in a fatal consequence to election petition. A lot of authorities listed there. Election petition as a special proceeding is specifically regulated by the Constitution of the Federal Republic of Nigeria, the Electoral Act, and other rules of procedure, such as the Federal High Court Civil Procedure Rules, the practice direction of the Honorable President of the Court of Appeal for the hearing of the election petition for the hearing of election petition and the election petition appeals. By Section 285(5) of the Constitution, an election petition shall be filed within 21 days after the date of the declaration of results of the election. By Section 285(6) thereof, an election tribunal shall deliver its judgments in writing within 180 days. These timelines are sacrosanct and cannot be extended by the court. It is tried law that under the first schedule of the Electoral Act, the election petition to be filed is well regulated. Paragraph 4, 5, and 6 of the Electoral Act provides that election petition shall be accompanied by a list of witnesses that the petitioner intends to call in proof of the petition. 2, written statements on oath of witnesses. 3, copies or lists of every document to be relied on at the hearing of the petition. A petition which fails to comply with subparagraph 5 shall not be accepted for filing by the Secretary. An election petition which does not comply with subparagraph 1 or any provision of that subparagraph is defective and may be struck out by the tribunal or the court. The word shall, used in this legislation, makes it mandatory for a petitioner to comply with the provision of the law in pursuing or prosecuting election petition. Failure to comply is fatal. Election petitions are fought on pleadings, competent and credible witnesses. Where a petition is deficient in pleadings and evidence, it is difficult to say it is proved, or that it is difficult to prove the same petition. In the instant case, the petitioner's pleadings were deficient. While they complained of non-compliance with the Electoral Act against first respondent, their own petitions were massively deficient in non-compliance with the said act. The lead judgment has elaborately dealt with these issues. When a court is called upon to determine an election dispute, he is called upon to do justice. Our notion of justice is doing justice is not that of doing justice according to the whims and caprices of the judges or the parties. It must be justice according to law. Justice according to law is also that which is neither based on technicality nor justice according to the suggestive clout of pressure groups, but as such as it substantially meets the demands of justice. This, with all respect, is what we have done in the lead judgment. I therefore concur with the leading judgment that these 3 consolidated petitions, having not been proved, are hereby dismissed. I abide by the consequential orders as made in the lead judgment.
I will call on my land brother, my immediate left, to deliver his own judgment.
I have read the lead rulings and judgments of my learned brother, H.S. Samani JCA, in the above consolidated petitions. I agree with his reasoning and conclusion in each petition and adopt same as mine. I add a few words for emphasis. Petition number 3. Ground 1 of the petition is that the respondent was, at the time of the election, not qualified to contest the election. The first complaint under this ground is that the purported sponsorship of the second and third respondents by the fourth respondents was rendered invalid by reason of the third respondent knowingly allowing himself to be nominated as the vice presidential candidate, whilst he was still a senatorial candidate for the Borno Central constituency. The controversy about the third respondent knowingly allowing himself to be nominated in more than one constituency was the subject matter in PDP against INEC and others, reported in 2023 LPELR 60457SC. The Supreme Court Paukoro JSC, Augi JSC, Ogumiju JSC, and Ajim JSC, in their concurring opinions, held that the third respondent, having withdrawn his nomination and personally delivered the notice of withdrawal to his party, fourth respondent in this petition, on 6 July 2022, he was no longer a candidate for Borno Central constituency senatorial election in his subsequent nomination as the vice president for the presidential election was not multiple nomination. The opinion of the Supreme Court of the Supreme Court, Paukoro JSC, Augi JSC, Ogumiju JSC, and Ajim JSC, is not a comment or observation made in passing. It is an exposition of the law on withdrawal of a candidate from an election and the allegation that the third respondent knowingly allowed himself to be nominated as the vice presidential candidate while he was still a senatorial candidate for Borno Central constituency. Concurring opinion forms part of the lead judgment, and it is meant to complement him by way of addition or an improvement on the issues resolved in the lead judgment. See Unwana against FCDA, Olorun Toba Oju against Abdurrahim, and both and others against Just Electricity Distribution Company PSC. Citations supplied. The Supreme Court, having rendered its considered and definite opinion on the validity of the nomination of the second respondent as vice presidential candidates of the fourth respondent, attempts to reopen the issue in this court is a misadventure. The second complaint is that the second respondent was at the time of the election not qualified to contest for the office of the president, as he was fined the sum of $460,000 for an offense involving dishonesty, namely narcotics trafficking, by the United States District Court, Northern District of Illinois, Eastern Division, in case number 93C 4483 on 4th October 1993. The contention of the learned counsel for the petitioners is that the order of forfeiture made by the court is a fine under Section 137(1)D of the 1999 Constitution of the Federal Republic of Nigeria. It is a settled principle of interpretation that when the words used in the provisions of the Constitution are clear and unambiguous, same must be given their plain and ordinary meaning, unless to do so will lead to absurdity. See Abegundi and other cases cited here. The context in which the word sentence is used in Section 137(1)D of the Constitution connotes formal pronouncement awarding punishment after conviction for an offense. Conviction is a finding of guilt after an indictment, arraignment, and trial. See Kole Osho against FRN, Mohammed against Olawumi, Modu against Federal Republic of Nigeria. Therefore, the words sentence, imprisonment, and fine used in Section 137(1)D of the Constitution definitely connotes only a punishment imposed on a defendant following an indictment, trial, and conviction for an offense. See Babangida Usman against the state. Citations supplied at 40 to 41. Sharif against Federal Republic of Nigeria. Citations supplied. In civil forfeiture or a non-conviction-based forfeiture proceedings, in civil forfeiture or non-conviction-based forfeiture proceedings, the government only needs to show by preponderance of evidence that the property is a proceed of crime or was used to facilitate a crime. Criminal forfeiture, on the other hand, is seizure of a property connected with a crime after obtaining conviction and as part of sentence or punishment for the crime. Civil forfeiture is not a conviction or verdict of guilt after an indictment, trial, and conviction. See Jonathan against Federal Republic of Nigeria, citation supplied, where the Supreme Court per Kaas JSC considered the provisions of Section 17 of the Advance Fee Fraud and Other Related Offences Act and persuaded by the decisions of the various courts across the world, held that civil forfeiture is an action in rem embarked upon when the interest of the government is merely to recover the proceeds of unlawful activity. The court also held that an application for interim forfeiture of property that is not predicated on conviction of the owner of the property will necessarily be an action in rem, because it is the recovery of the property that the law aims at. A forfeiture order by a foreign court can only be accepted and recognized by a court in Nigeria for the purpose of Section 137(1)(d) of the Constitution, if it is made after an indictment, trial, and conviction, and properly proved as required by Section 49 of the Evidence Act. In addition, the conviction and sentence must be shown to have been a product of due process of law. Compliance with the process of law has to be determined by the procedure and standard set by Section 36, subsection 5 and 6 of our Constitution. The forfeiture order being relied on by the petitioners has not been shown to be a result of a process similar to the one set by our Constitution for a trial of a defendant for an offense. The appellant counsel relied on Austin against United States, citation supplied, and Teams against Indiana, decided on 28 February 2019. The forfeiture proceedings in the two cases were instituted as part of criminal proceedings after conviction of the defendants. Secondly, forfeiture was regarded as punishment for the purpose of protecting the constitutional rights of the defendants against imposition or infliction of excessive bail or excessive fines or cruel and unusual punishment for an offense. Eighth Amendment provides that excessive bail shall not be required, nor excessive fines imposed, nor cruel or unusual punishments inflicted. In United States against usury, 1996, other citations supplied, the United States Supreme Court considered the relationship between punishment and civil forfeiture. The court held that in rem civil property forfeiture did not constitute a punishment, such as fine, for purposes of double jeopardy clause of the Fifth Amendment. In Abacha against Federal Republic of Nigeria, citation supplied, forfeiture was also defined in the context of the doctrine of double jeopardy. The appellant contended that the state could not indict and prosecute him for the offenses of conspiracy, receiving stolen property, dishonestly and concealing stolen money after forfeiting the properties listed under forfeiture of assets, etc., certain persons decree number 53 of 1999. The rejection of the plea of double jeopardy means that the court did not consider the forfeiture under the forfeiture of assets, etc., certain persons decree number 53 of 1999 as punishment. From all the above, it is clear that a non-conviction-based forfeiture, being civil in nature and an action in rem, can in no way be equated with a sentence of imprisonment or fine imposed for an offense involving dishonesty or fraud or for any other offense to disqualify a person from contesting for election to the office of the President of Nigeria. An indictment, arraignment, trial, and conviction are necessary preconditions for disqualification of a person under Section 137(1)(d) of the Constitution. Grant 2 of the petition is that the election of the second respondent was invalid by reason of corrupt practices or non-compliance with the provisions of the Electoral Act. The allegations are basically predicated upon electronic transmission of the election. A global reading of the Electoral Act 2002, particularly sections 47(2), 61(5), 62(1), 65(1) to 8, will show that what the Act provides for is manual transfer and manual collation of results by collation officers at various physical collation centers. There is no provision for electronic transmission or IREF or electronic collation of results in the Act. By paragraphs 38 and 48A of INEC Regulations and Guidelines for the Conduct of Elections 2022, the first respondent made provision for electronic transmission and physical / manual transfer of election results from the polling unit. However, paragraph 48C provides that if no result has been electronically transmitted from the polling unit, the provision of paragraph 93 shall be applied. Paragraph 92 categorically provide that at every level of collation where INEC copy of collated results from the immediate lower level of collation exists, it shall be adopted for collation. By paragraph 93, where INEC hard copy and electronically transmitted results from the immediate lower level of collation do not exist, the collation officials shall use duplicate hard copies issued to the Nigerian Police Force and agents of political party to collate results. It is therefore not correct that it shall not be possible to collate results of the election where results have not been electronically transmitted. By law, the INEC Regulations and Guidelines for the Conduct of Elections 2022 is subordinate to the Electoral Act, where a provision of the guidelines conflicts with the Act. The Act prevails. See Odeneye against Efunuga, in Yesom against Peter citation supplied. Section 134(2) of the Act. By Section 134(2) of the Act, any circular, press release, promise, or stated intention of INEC that is in conflict with or expand the provisions of the Electoral Act cannot prevail over the Act. INEC guidelines cannot be elevated above the provisions of the Electoral Act so as to elevate electronic transmission of results over and above manual and physical transmission of hard copies and manual collation of results as prescribed as provided for by the Act, to the extent that non-compliance with the regulation automatically invalidates an election. PW4, the professor of mathematics, presented to this court as an expert witness, confirmed under cross-examination that IREF is not a collation system. He also confirmed that whether or not transmission to IREF failed or the image of result on the IREF is blurred will not change the result entered onto Form ECATA at the polling unit level. Under cross-examination, PW12 stated that petitioners had 133,000 agents. He was not a party agent at any of the INEC designated polling units or collation centers. None of the 133,000 party agents was called to testify that there was a dispute regarding any collated result at any polling unit, registration / ward, local government, state or national collation centers. So as to enable the collation officers at the various levels of collation to activate the process prescribed under Section 64, subsection 6 of the Act. PW12 stated that the petitioners believed they have won the election if the results had been uploaded. When asked about the score of the petitioners by which they claimed to have won the election, he answered rhetorically that how are they supposed to know the score when the result was still being uploaded on the IREF? So, this petition is about the belief of the petitioners that they will have won the election if the results had been uploaded on the IREF. Election petition is a serious issue. A petitioner is not permitted to engage in fishing expedition or a roving inquiry, as the petitioners herein did. It is clear from the pleadings and the evidence of PW12 that the petitioners were from the onset engaged in a wild goose chase and inquisitorial adventure. By paragraph 9 of the regulation, a political party has a right to appoint one person as its polling agent for each polling unit, collation center, and one representative at each point of distribution of electoral materials in the constituency where it is sponsoring candidates or candidates for an election. According to PW 12, the petitioners exercised that right and had 133,000 party agents in the election. I stated earlier that none of those 133,000 polling agents was called, and not a single one of result forms collected by any of the agents was tendered in evidence. Electoral Act provided a candidate who wishes to challenge any result declared by INEC with a potent material, which are the forms on which results are entered, signed by the first respondent officials and party agents, and a duplicate copy of it is given to the party agent. Any serious candidate ought not to depend on INEC for materials to prosecute his petition. By Section 167D of the Evidence Act, the failure of the petitioners to produce election result forms collected by their agents raises a presumption that if those forms had been produced, it would have been unfavorable to the petitioners. The first respondents in their pleadings and evidence through DW1 stated that the delay in uploading the results from the polling units to the IREF was due to a technical glitch which occurred on their transmission system, which was rectified within a few hours. All that the petitioners could do was to bring a PW1, a member of the second petitioner, who claimed to be a software engineer and an employee of Amazon. She had the temerity and the audacity to claim authorship of a document, a word of which does not belong to her. The first respondent never claimed that the glitch occurred on Amazon Web Services. It is obvious from PW7's evidence that the petitioners did not understand the explanation of the first respondent, or were just fixated on their belief that they won the election without any cogent and credible evidence. And they did not even bother to place any such credible evidence before this court. Were they expecting the court to go and gather evidence from the street or from the market, or to be persuaded or intimidated by threats on social media? That is not the way of the court. See the admonition of Toby JSC in Buhari against Yaradua on a similar situation like the instant case, citation supplied. Thus, the petitioners not only failed to prove non-compliance with the Electoral Act, they failed to prove that the non-compliance substantially affected the result of the election declared by the first respondent. It is settled that even if non-compliance with the Electoral Act is established, if there is evidence that despite the non-compliance, the result of the election was not affected substantially, the petition must, as a matter of law, be dismissed. See Abubakar and others against Yaradua, citation supplied. The third ground of the petition is that the second respondent was not duly elected by majority of lawful votes cast at the election, having not obtained 25% of the votes in FCT. The provisions of the Constitution must be read together to discover the intention of the framers of the Constitution. A court of law has no power to take away or limit the words of the Constitution or import into it what it does not say. Elelu, Abib, and another. Against the Honorable Attorney General of the Federation, citation supplied. A narrow interpretation that would do violence to the provisions of the Constitution and fail to achieve the goal set by it must be avoided. Our Constitution is based on principles of freedom, equality, and justice in all ramifications, and is for the purpose of consolidating the unity of our people. Section 41 and 2 of the Constitution, 14(1) and 2, states that the Federal Republic of Nigeria shall be a state based on the principles of democracy and social justice. The participation by the people in their government shall be ensured in accordance with the provisions of the Constitution. The right to vote is at the foundation of our democracy. It is the most potent and priceless opportunity a citizen has to have a say in who governs. Every citizen who is qualified to vote must be afforded equal opportunity to cast his or her vote to elect leaders who governs. Our constitutional principles of freedom, equality, and justice, democracy, and social justice means that the vote of each citizen shall count. Each and every vote should count equally. No vote should weigh more than the other. The principles of equality of vote must be protected by the court. The interpretation of Section 134(2) of the Constitution being urged on us by the petitioners is an unjust manipulation of the Constitution to create inequality of votes. It negates the principle of equality and justice, democracy and social justice, and participation of the people in their government enshrined in our Constitution. It strikes at the very foundation of our Constitution. It is capable of further dividing the citizens of this country. The politicians are good at using all sorts of means and sentiments to divide the citizens of this country. The interpretation being urged on us is their latest invention in that regard, and unfortunately, they found a ready alliance with those who should know better. The interpretation being urged on us is squarely against the letters and spirit of our Constitution, and it is hereby rejected. Based on the above and the further reasons lucidly explained in the lead judgment, I too dismiss the petition. 04. I have had a preview of the reasons given in the lead judgment of my learned brother. I agreed with his reasoning and conclusion. I adopt same as mine. I hereby abide by the orders made therein. As for 05, I adopt my reasoning in respect of the third ground, and I also dismiss the petition. On the whole, I too dismiss each of the three consolidated petitions. I abide by the order made in respect of the petition in the lead judgment.
My learned brother, by my extreme right, shall present his own judgment.
Long last.
There's still one more? Yeah? It's not complete, we do know.
No, just right. Okay, just right.
I'd earlier read in draft the rulings and judgments of my learned brother, Aruna Simon Samani, in these consolidated petition numbers CAPEPC 03, 04, and 05, 2023. I am in complete agreement with His Lordship's reasoning and conclusions on all of them. First, for petition numbers PEPC 04, 2023, that is the Allied People's Movement petition, I am of the very fixed view that the issues agitated by the petitioner therein concerning third respondents alleged disqualification by reason of matters connected to or surrounding his running mate's nomination and relinquishing of his earlier nomination by his party for the Borno Central Senatorial District having been settled on their merit by the Supreme Court in its judgment, in appeal numbers SCCV 501, 2023, in third and first respondents' favor therein, with the Apex Court even holding that the said issues did not disqualify them, that decision constitutes issue estoppel. being status defining and so judgment in rem, it binds every person, including non-parties to the suit, like the petitioner in petition number CAPC 04-2023, C. Kotun, and Oyekomi, Soson, and Odemuyiwa. Furthermore, by the doctrine of stare decisis, it also binds this court. In fact, it will, in my humble opinion, amount to judicial heresy for this court to involve itself in inquiring by whatever guise into that same issue already settled by the Apex Court. Coming to petition number CA03-2020 of Peter Obi and another versus INEC and others, and CAPC 05-2023 Atiku Abubakar and another, again I am of the very fixed view that the two sets of petitioners did not by any means discharge the burden on them of proving that the results of the presidential election of 25th February 2023 as declared by first respondent were incorrect. Incidentally, their burden is even made heavier by the legal presumption that the votes of an election declared by the official organizing body that INEC are correct, and it is for the person asserting the contrary to prove it, Buhari and INEC, see Buhari and INEC. Even their resort to first respondent's failure to keep its initial promise to upload poly-unit results of that election to its result being portal IREV real-time, which failure the alleged evidences election manipulation, does not help them. And specifically on this allegation of manipulation of election results, the point must be made that since it is their case that from the word go that the election results in issue were manipulated by first respondent in favor of second respondent, and specifically that the manipulation took the form of, quote, programmed failure of the technological device, machines, that is beavers, by first respondent by intercepting the results, quarantining, warehousing, and filtering such results before releasing them to the IREF portal. 2, INEC replacing its in-house IT expert at the 11th hour with a rogue staff, all in the bid to completely control, monitor, and filter data transmitted from the beavers devices to the electronic system. And 3, that Globacom, the internet provider for the beavers and electronic system, was also disconnected by first respondent to enable it to manipulate the results, with the petitioners in CA, that is the Atiku petition, even going further to undertake to call evidence to prove all those allegations. The burden of proof was on the petitioners to prove those assertions, and that is regardless of whether they are positive or negative. After all, it is they who would have failed in the case if no evidence at all was adduced in their petitions. See on that sections 131 of the Evidence Act, Buhari and INEC, Aladegbemi versus Fasomade, Elias and Disu, Dashi and another, Abrat and Railway, Northeast Railway Company. I have taken all this time in making this point because of the argument of both sets of defendants that they only made negative assertions in their petitions, when they alleged that there was nothing wrong with first respondents transmission system and IREF, so they had no burden to prove it. That the burden of proof was on the respondents who they said positively asserted glitch in real-time transmission of their results. Petitioners who directly made manipulation of its e-transmission system by first respondent to favor second respondents, a pillar of their case, cannot be held to say it is respondents and not them that had the burden of proof in this case. Incidentally, that assertion of petitioners that INEC simply closed down or blocked its IREV and an e-transmission system from the public to enable it to manipulate the election results in favor of second respondent also takes me directly to the more important question in the petition, namely, whether that allegation is even worthy of belief, given the results declared by INEC for them and the second respondent in the election. To answer that million-dollar question, I deem it necessary to resort to the probabilities arising from the facts of from the facts of the case. That test, otherwise called the probability test, which test celebrated Judge Chukwudifu Akonne Oputa, JSC, always maintained, and I quote him, is the surest road to the shrine of truth and justice. See the cases of, he said so in the case of Dibi Amaka and others, and in Ojegele and others, the first 1989 and the second 1988. I gave the citations. Here, the assertion of petitioners is that first respondent, INEC, merely used the excuse of glitch in its IREF portal to block the public from seeing its poly unit results real time so that it could manipulate, and indeed actually manipulate, the 25th February 23 presidential elections in favor of second respondent. It is their further contention that the manipulation of IREF by INEC with the said phantom glitch in favor of second respondent was nationwide. The question is, do the results declared by INEC support that hypothesis? They say the taste of the pudding is in the eating. I shall therefore now try to walk us through some of these election results to see if that assertion of petitioners is supported by the results declared by INEC and so probable and worthy of belief. In doing that, I shall randomly pick on the results of some states of the Federation and the Federal Capital Territory. I shall be relying on the state summary of the results, that is from ECD, declared by INEC and has also attached their petition by the petitioners in CAPC 05, that is Atiku's case, which result was also tendered by both sets of petitioners and respondents. So I take first Abia State. There, second respondent, the alleged favored candidate of INEC, for which it was said to have shut down his IREV to manipulate results, only garnered a miserly 8,914 votes. That is as against the Labour Party, which by INEC's declaration polled as many as 327,095 votes. Even the other set of petitioners, complainants, the PDP and its candidates, scored more votes in Abia than INEC's purported favored candidate. They also scored 22,676 votes in Abia and was so recorded by INEC. Those votes alone are close to 3 times the votes of second respondent, for whom INEC was said to have manipulated results by closing down its IREV, so that the public would not witness its manipulative activities in favor of second respondent. In Enugu State, the same favored quote-unquote candidate, second respondent, was again declared credited by INEC to have polled only 4,772 votes in the entire state. Meanwhile, the Labour Party and its candidates were again declared by manipulative and quote-unquote and unfriendly INEC to have scored as much as 428,690 votes in that state. In the same Enugu, PDP and its candidates was also declared by INEC to have polled 15,745 votes, a number that is also nearly 3 times the votes of the so-called favored second respondent. In Anambra State, the same purported favored candidate, second respondent, was declared by its alleged friend INEC to have scored only 5,111 votes. Meanwhile, the Labour Party, whose candidate, first petitioner in CAPC, I must take judicial notice of, vide Section 124 of the Evidence Act, is from that state, again was declared to have polled as much as 584,621 votes. Again, like Enugu State, the PDP and its candidate was declared by INEC to have polled 9,036 votes, a number that is also nearly double the votes of, quote, INEC favored, end quote, second respondent. In neighboring Delta State, the same INEC favored candidate, second respondent, was declared by INEC to have scored 90,180 votes. That is as against the Labour Party and its candidate, which is credited by the same bias, quote unquote, INEC, to have scored as much as 179,917 votes. In that same Delta State, the PDP and its candidates scored 161,600 votes, again nearly double the votes of second respondent. In Adamawa State of the PDP and its candidate, the same favored second respondent was declared by INEC to have scored only 105,648 votes, while the PDP and its candidate were declared by the biased, quote unquote, INEC to have scored as much as 214,012 votes. In Imo State, the same purported INEC favored candidate, second respondent, was declared by INEC to have scored only 66,406 votes, while the Labour Party and its candidate is declared by the same INEC to have polled as much as 360,495 votes. In Ebonyi State, the Labour Party again scored as much as 259,738 votes. That is as against alleged INEC favored second respondent, who by INEC's declaration, that is his friend's declaration, again polled a relatively miserly 42,402 votes. The PDP is said to have scored 13,503 votes there. Even in Lagos State, where second respondent was once held sway as elected governor, the Labour Party and its candidate was again declared by bias, quote unquote, INEC to have beaten second respondent with almost 10,000 votes. Labour Party was declared by INEC to have polled 582,455 votes as against 572,606 polled by second respondent and so declared by INEC. It is a similar story in the Federal Capital Territory of Abuja, where INEC has its headquarters and supposedly carried out, directed, all its, quote, manipulative and biased activities in favor of second respondent that petitioners claim he did in the election. Second respondent and his political party still lost there. In fact, by the result, second respondent-friendly, quote-unquote, INEC declared in the Federal Capital Territory of Abuja, second respondent could not even make 25% of the votes, total votes cast there. He was said to have polled only 90,902 votes. That amounts to just 18.991% of total votes cast in the FCT, yet INEC declared that result. That is as against 281,717 votes, amounting to 58.856% of the total votes, the same INEC declared for Labour and its candidate. There are also other states, including Katsina State of the immediate past president of this country, a member of the second respondent, who was still in office at the time of the elections, in fact, as I take judicial notice of video section 124 of the Evidence Act. There again, second respondent and his party, the APC, also the then sitting president, was declared by the same INEC to have lost to the petitioners in CAPC 05-2023, that is Atiku Abubakar. Now, if all these results declared by INEC for each of the states for the two sets of petitioners and second respondent is anything to go by, then INEC must be an abysmally poor manipulator, if not even an imbecilic one. Surely it would not go through all the stress of closing down its IREF and blocking the public from seeing its manipulative efforts in favor of second respondent, as alleged by the petitioners, only for it to still end up favoring the petitioners with jumbo votes and posting miserly figures for its favored second respondent. It is said that all men stamp as probable that which they would have said or done under similar circumstances, and as improbable that which they themselves would not have said or done under the same set of similar circumstances. Things inconsistent with human knowledge and experience are properly rated as improbable. End quote. See again Oputa JSC on this, in Onwa and the state and Bozin and the state. At any rate, why did any of the two sets of petitioners not tender even a single polling unit result issued by INEC to their polling unit agents to support their claim of manipulation of election results by INEC, even as they all agreed that they had agents in the polling units? I have thought that this is the best and most effective way of proving the manipulation of election results alleged by them. After all, the polling unit is the only place where voting takes place, and so also constitutes the building block of election results. That much is stated in paragraph 90 of INEC guidelines and for the election, and also Wobuda Nono and Awusi and Odele. In short, the allegation of the petitioners that INEC shut down its IREF to manipulate votes for second respondent just does not add up for me. If anything, the probabilities arising from the results INEC declared nationwide as illustrated above rather seem to me to eloquently support its position that its inability to upload the polling unit results real time, as earlier promised, was not deliberate but caused by technical issues outside its control that afflicted its e-transmission system, which issues it claims made it impossible for its e-transmission system to map the uploaded polling unit results for the presidential election to any specific state. That it claimed is unlike the much smaller National Assembly elections that were conducted simultaneously with the presidential election. It is that phenomena it describes as glitch that was giving it an HTTP 500 error, which eventually resultantly delayed real-time public viewing of the said polling unit results. That conclusion also takes me to another big issue in this case, namely the evidential value of the European Union Observer Mission report on the 2023 presidential election, over which quite a mountain has been made up by both sets of petitioners. That report was tendered by the petitioners in petition number PEPC, that is OB and another, as Exhibit X2, and by the petitioners in CEPEC 05 as Exhibit RA27. The impression given by both sets of petitioners is that the said report, which in any case has been even ruled admissible by us in petition number CAPEPC 03-2023, is like gospel truth of what happened in the election. And so it must be accepted by this court, and the conduct of the presidential election declared corrupt or at the very least below par, regardless of whether or not its authors presented themselves in court to defend their opinions. That stance, I am afraid, is a non sequitur. It's a complete non sequitur. Without the makers of that report presenting themselves in court to face cross-examination, to authenticate their opinions, that report, and I dare to add even the ECOWAS report of the same elections, tendered by second and third respondents in petition numbers in the two petitions, are completely valueless and inadmissible for the purposes of authenticating the opinions expressed in them by the makers. See first on that the cases of Nyesom and Peter Said and Said Yakowa. It also makes no difference that the said reports have been put in the form of print Books, it must be noted, cannot be cross-examined. On this, I find support in the celebrated case of Idudu and others versus Okumagba, where the Supreme Court, 1976, where the Supreme Court had this to say, and let me quote what the Supreme Court said. It said, as for the law involved in Idudu and Okumagba, we would like to point out that it is now well settled that there are 5 ways in which ownership of land may be proved. In our view, not only was the evidence of the witnesses, that is continuation, not only was the evidence of the witnesses called by the appellants rightly rejected by learned trial judge for good and sufficient reasons, we also think that he was right in not attaching any weight to the views expressed in the book cited in support of such traditional evidence. As Lionel Brett JSC, as event was rightly in our view once pointed out in a learned address given by him at the University of Lagos to the Nigerian Association of Law Teachers, smaller quote again, the courts are not to be hypnotized by the authority of print. The crucial fact is that books cannot be cross-examined, either as to the opinions expressed or as to the claims of the author to have special knowledge. If the author is living, there is no reason why he should not be tendered as an expert when this difficulty would vanish. Small quotes, end quote of that side. Then the Supreme Court went on to say, moreover, none of the authors of these books in that Okumagba's case testified in support of the views stated therein, and no explanation was given for the omission. For all these reasons, we share the apprehensions of the learned trial judge about the value or weight of the traditional evidence as narrated by each of these authors, particularly as the authenticity and impartiality of the sources of their narratives cannot, for obvious reasons, be easily ascertained, end quote. I want to say that is the exact same situation we are confronted with here as regards both the European Observer Mission report and its brother ECOWAS Election Observer report. For purposes of proving the opinions expressed in them by their makers, neither of them is of any higher value than the mere sheets of paper on which it is recorded. And for those who, like the petitioners, are enamored by the now very familiar patronizing judgments passed on elections, regularly passed on elections, by European Election Observer Missions every 4 years. Even as the same Europeans have maintained a deafening silence on the never-ending complaints of former President Donald Trump, that the year 2020 presidential elections of the United States that saw him out of office was also a fraud, it may interest them to know that Sir Justice Lionel Brett, who made the comment cited approvingly by the Supreme Court in Okumagba's case that I read above, was also a European. He's British. He was British. I think I intend to stop here. I think I've said enough. It is for these few additions, but much more for the far more illuminating reasons advanced by my brother Haruna Samani JSC in his rulings and judgments, which reasons I concur with without reservation, that I also hold all 3 consolidated petitions not proved and thereby enter another dismissing all of them, and I affirm the declaration of second respondent Bola Ahmed Tinubu by second respondent as the person duly and properly returned winner of the 25th February 2023 presidential election of this country and duly elected president of the Federal Republic of Nigeria. I also abide by all other consequential orders, including that as a cause contained in the leading judgments.
I now invite my learned brother by my extreme left to present his own judgment.
Well, last but not the least, I've read before now a draft of the lead judgment just delivered by my learned brother Haruna Simon Samani, JCA, in the 3 consolidated petitions of CAPEPC 03-2023, CAPEPC 04-2023, and CAPEPC 05-2023. I'm in agreement with and I adopt all the reasons and conclusions stated therein, both in relation to the rulings on the objections and the merits of the 3 consolidated petitions. Although all the issues in petitions number CAPEPC 03 and 2023 and CAPEPC 05-2023 have been exhaustively resolved in the lead judgment, I deem it only pertinent to highlight a fundamental vice which has affected the 2 petitions, especially as it relates to the petitioner's essential contention or premise upon which they predicated those 2 petitions. In those 2 petitions, the petitioners have premised their ground that the presidential election conducted on the 25th of February 2023 is invalid by reason of corrupt practices and non-compliance on their contention that by the provisions of the Electoral Act 2022 and the regulations and guidelines for the conduct of elections 2022, the first respondent, INEC, is mandatorily required to electronically transmit election results to the collation system and to the INEC results viewing portal, the IREV. They contended that the first respondent had deliberately refused to comply with those mandatory provisions and had manipulated the results of the election through various corrupt practices which they allege in those two petitions. However, in both petitions numbers TEPC 03-2023 and PAPC 05-2023, Exhibits X1 and X2, which were tendered respectively to show that the Labour Party, the second petitioner in petition number PEPC 03-2023, had before the elections approached the Federal High Court Abuja for the determination that, and I quote, by the provisions of the Electoral Act 2022, INEC, the first respondent, has no power to opt for manual method other than the electronic method provided for by the relevant provisions of the Electoral Act, unquote. And I quote again, an order of this Honorable Court directing / compelling the respondent to comply with the Electoral Act 2022 on electronic transmission of result in the forthcoming general elections, unquote. In that judgment, the Federal High Court Abuja Division had dismissed the suit and held that, and I quote, there is nowhere in the above cited sections where the Commission or any of its agents is mandated to use an electronic means of collating or transferring of election results. If any, the Commission is only mandated to collate and transfer election results and number of accredited voters in a manner or way deemed by it. Additionally, this court's attention was referred to the judgment of this court in appeal number CA LAG CV 332-2023, APC versus Labour Party and 42 others, delivered on the 19th of June 2023, in which this court set aside the judgment of the Federal High Court, Lagos Division, in another suit number FHC LCS 370-2023, Labour Party and others versus INEC, filed by 8 Labour Party, the second petitioner in PEPC 03-2023, before the Lagos Division of the Federal High Court to obtain an order of mandamus compelling INEC to electronically transmit or transfer election results as provided in its regulations, after losing in the Abuja Division of the same court. In the judgment of this court of 19th of July 2023, in appeal number CA LAG CV 332-2023, this court particularly held at pages 23 to 24 thereof that, and I quote, it is difficult for suit number FHC LCS 370-2023, which gave rise to this appeal, to escape the level of abuse of court process. I said so because the objective of the suit is to compel the 43rd respondent to adopt a particular way of transmitting or transferring the results of the election in Lagos State. This objective is not in any way different from what the objective of the first respondent wanted to achieve in suit number FHC ABJ CS 1454-2022. Similar parties are the same in the two suits. The second to 42nd respondents are members of the first respondent, which litigated the suit number FHC ABJ CS 1454-2022. The second to 42nd respondent's interest is the same with that of the first respondent, so they are the first respondent's previous. Both suits are against the same defendant, that is the 43rd respondent hearing, and filed in the same court, albeit different divisions of the court. The decision of Emeka Nwite J of Abuja Division of the lower court, which dismissed the first respondent's suit, holding that on the interpretation of the provisions of section 60 subsection 5, 62 subsection 2 of the Electoral Act 2022, INEC, the 43rd respondent hearing, is at liberty to prescribe or choose the manner in which the election results shall be transmitted, finally settles the issue. I therefore find in suit numbers FHC LCS 370-2023, which is herein being appealed against, all the trademarks of the cause of an abuse of judicial process, unquote. Exhibits X1 and X2, tendered in petitions number 03 and 05 respectively, as well as the decisions of this court in appeal number CA LAG CV 332-2023 Supra, are subsisting judgments of court which are not only binding on the parties, but which constitute issue estoppel to the petitioner's essential contention in the two petitions. that the first respondent is by Electoral Act 2022 and the INEC regulations mandatorily required to electronically transmit and collect results of the presidential election. The doctrine of issue estoppel is that once an issue has been finally decided by a competent court, the issue will not be allowed to be relitigated by the same or even different parties. See Cotton versus Oekami and another, APC versus PDP and others, Ezewani versus Onwodi, citations on the record. Indeed, in Ezewani versus Onwodi, the Supreme Court, Pauputa JSC, specifically held as follows. Strictly speaking, therefore, the concept and value of an estoppel is to bar a person from denying or asserting anything to the contrary of that which he has, in the contemplation of the law, been established as the truth, either by the acts of judicial or legislative officers or by his own deed or representation, express or implied, unquote. It is clearly evident that the decisions in Exhibits X1 and X2 tendered in the two petitions, respectively, as well as the decisions of this court in appeal number CALAG CV 332-2023, APC versus Labour Party and 42 others, have dealt a death knell to the petitioners' contention around which they have built their claim of non-compliance and corrupt practices in those two petitions. Namely, that the first respondent is by the provisions of Electoral Act 2022 and the regulations and guidelines for conduct of elections 2022 mandatorily required to electronically transmit election results to the collation system and to INEC result viewing portal, which is the RF. Apart from this fundamental deficiency, which I have highlighted, the lead judgment just delivered had exhaustively considered all the other issues and rightly concluded, in my view, that the petitioners in petitions number PAPC 03-2023 and CAPEPC 05-2023 have failed to establish all the allegations contained in the two petitions. I adopt all those reasons and conclusions stated therein and also find the two petitions devoid of merit. Petition number 04, as regards that petition, the petitioner has, under the guise of challenging the qualification of the third respondent to contest the presidential election on the ground that he had violated the provisions of Section 142, subsection 1 of the Constitution of the Federal Republic of Nigeria 1999, basically challenged the validity of the nomination of the fourth respondent by the third respondent as his running mate in the 25th February 2023 presidential elections. In concurring with the lead judgment just delivered, I also hold the considered view that the status of the nomination of the fourth respondent as the running mate of the third respondent and vice presidential candidate of the second respondent had been finally decided by the Supreme Court in appeal number SCCV 501-2023, PDP and INEC, delivered on 26th of May 2023, now reported as PDP and INEC and three others, 2023 LPLR 60457 SC, the certified true copy of which was tendered as Exhibit X1. In the concurrent judgments of their lordships, Okoro, Augi, Ogunwumiju, Agim, justices of the Supreme Court, they have all determined as proper the nomination of the fourth respondent as vice presidential candidate of the second respondent. As for the petitioner's argument that the pronouncement of the Supreme Court in those concurring judgments is an obiter dictum, the clear statement of Ogunwumiju JSC has left no one in doubt that the Apex Court decided the merit of that case. My Lord Ogunwumiju JSC clearly stated at page 74, paragraph C of that judgment that it is apt in this type of political case of public interest to look into the merits of this case, unquote. It is settled law that once the issue relating to the status of a person or a thing is finally and substantively determined by a competent court, such a determination constitutes estoppel to any subsequent proceedings on the same issue. See APC, PDP, and others, Inakoju and others was the delicate citations on the record. Now, for all this, and all the detailed reasons succinctly stated in the lead judgment just delivered, I also hold that this petition is lacking in merit. Having also found that no merit exists in all the above three consolidated petitions, I join my learned brothers Amani Jesse in dismissing all the three petitions and abiding by the consequential orders made in the lead judgment.
Well, with the judgment delivered by my learned brother Abba Mohammed, we have discharged our responsibility to the nation. We have concluded the hearing of this petition, and we have concluded the delivery of the judgment. So we thank the Almighty God for bringing us this far. All these months, both counsel in all the petitions have labored, they have tried to represent their clients creditably. And we thank you for their assistance, because their assistance have helped us to reach our conclusions in this judgment. So as we leave today, we hope that very soon, both us and council will meet in our normal cases. Yes. These cases have tended to put a distance between us. But when we resume in our normal cases, we shall see and interact better. Thank you, and God bless us all.
Thank you very much, my lords. On behalf of the petitioners, with all sense of responsibility and urgency, there's a little request we want to make, given our severely limited time by the practice directions to exercise our constitutional right of appeal. We will request, because our time starts running today, if we can have the copies as we leave today, so that, because any day that we lose depletes our right. We know the day is far spent. It is our humble request, so that the registry, once we leave, will be able to collect from them. We are very grateful, my lords.
Well, I am sure learned senior counsel is aware of the time now. It's 10 o'clock now. And, well, it's unfortunate. We understand your constraints, but you have to bear with us to tomorrow. Yes. Hopefully, you know, the judgments are a bit bulky. It's a consolidated judgment. We have to put
tomorrow we can have them from.
Yes, we have to put everything together, bind them, and give it to council.
We are very grateful.
Yes.
Tomorrow, my lords.
Wait. So we thank you for all the efforts you have put in. Thank you. Forget now.
My lords.
So, are they?
Yeah, sorry, my lords. I know the day is far spent. I thought my senior colleague will actually thank my lords for the industry put into this judgment. It is a well-considered judgment, and these judgments will no doubt change the face of our electoral jurisprudence. We have traveled this part of history this past few months, and today we have reached the end of it. We pray that that we all learn from it. We have all learned from each other during the course of our stay here. We salute you, my Lord, for the clear, detailed review of the pleadings, the issues, and the evidence in the petitions, especially on the issues surrounding technology. That was an area we thought we were going to have problems.
Please be brief.
But we thank you, my Lord, for this judgment, and we are very grateful. Yes. Thank you. God bless you, and God bless the Federal Republic of Nigeria.
Yes.
Well, my lords, mine is a short one. I thank your lordships. I think earlier on, my lord, there was supposed to be a misunderstanding. I apologize for that. It wasn't the intention at all. I appreciate your lordship's industry, and this work is not easy. I don't think I could have done any of the jobs your lordships did this evening. From 9:30 till now, I would have lost my voice. But I thank your lordships, and I pray that the bar and the bench continue to have a good relationship in all things. Thank you very much.